पवन एक विपिन मल्होत्रा के नाम से सर होंगे, उनको कर ऐड।
सबको ले लो, सबको, तभी चालू होगा। YouTube भी शुरू करो, क्योंकि लोग कह रहे हैं कि 40 लोग वेटिंग है वहां पे।
लाइव कर दे सर YouTube पे।
और क्या, विपिन जी आगे शुरू करवाइए ना। दे हो गया भाई लाइव।
योगन लाइव कर दे।
हो गया
ठीक है।
विपिन जी प्लीज बिगिन।
Hello, am I audible? Hello.
Yes, sir. Please begin.
Okay, Professor Cole has joined.
No, so far not. So you please start.
Actually, Zainab.
Yes, sir.
Okay. Actually,
why don't you start, Zainab?
Just a minute. Let me call Professor Cole because
we are starting. Zainab is starting. You call Vipin. Zainab, start, please.
Okay, sir. When you align your actions with your essence, you become a beacon that amplifies your presence. Good morning, everyone. I am Zainab Khurshid, a third-year student of BA Political Science Honours from Sri Aurobindo College, Delhi University. I would like to extend my warm welcome to everyone present here for the National Labour Law Day Conference organised by BSK Legal in collaboration with Sri Aurobindo College, Delhi University. As we all know, the rights of laborers have become a matter of much intellectual and academic discussion since the onset of the global pandemic COVID-19. The migration and loss of employment issues have created massive uproar among the masses. The human rights of laborers and their families have been degraded due to inaction of governments. In the backdrop of such circumstances, it is necessary to reckon to the possible issues and solutions to the existing problems. Through the conference, intellectuals will ponder over the possible ramifications and way out of the crisis. The theme of the e-conference for today is Labor Rights Amidst Global Crisis, Challenges and Solutions. Today we have here with us Mr. Sanjay K Chadha, sir. He is the founding managing partner in the litigation, arbitration and labor law compliances of the firm BSK Legal. By virtue of his supervision and 25 years of experience in the legal profession, the firm is successfully handling cases in over 600 districts throughout the length and breadth of the country. He has also served as a sole arbitrator in various cases. Sir completed his master's from SRCC, Delhi University in 1992, and LLB from Campus Law Center, Faculty of Law, Delhi University, 1995. Sir was a gold medalist in Delhi University and has aced many All India level exams. He is a prominent contributor to the news and print media, regularly featured in newspaper columns and TV interviews. I request Sir to kindly welcome the gathering. Sir?
Okay.
Yes, sir.
Welcome everybody in this conference on labor law. And this conference has been organized under the serene circumstances. Most of the students are not well, even organizers are not well. And despite that, we are enthusiastic about celebrating the Labor Day, because that is very important as far as the whole humanity is concerned, because it is because of our uh, labor's fruit we have achieved our comforts everywhere in the world. And we salute International Labor Organization for this purpose, that it had given the slogan that poverty anywhere is threat to prosperity everywhere. So rights of laborers are sacrosanct, but at the same time, we have to achieve certain developmental goals. So the process of industrialization has to go in competing these two fold goals, wherein the rights of laborers are protected, at the same times the economic growth is achieved. So we have come a long way in the checkered history of labor laws. And if you remember, in 1886, for the first time in Chicago, there was Pan America strike by the workers to demand their fair wages, to demand the 8 hours work. And then the same movement spread in France, in USSR, and in various other countries. And it is from that day onwards, that was on the 1st May, the bomb blast took place in Chicago to diffuse the crowd of workers. And at the same time, in 1889, France acknowledged the rights of workers, and they started celebrating the 1st May as the Workers' Day. The same thing was done by US. The Cleveland president in 1884 acknowledged the 1st May as the Workers' Day, and ILO in 1920 continued with this, tradition, and declared the International Labor Day on 1st May every year. India, however, started its journey, of celebrating the 1st May as a Labor Day on in 1923, and till then, British India, we had several enabling labor laws like Workers' Compensation Act, Trade Union Act, Industrial Dispute Act. They were made by the British Parliament. And right now we have around 50 central labor laws, and more than 200 labor laws in states, because the labor law falls in the concurrent list. States and center can both make labor laws. So this jumble of labor laws has created lots of problem for the judiciary, even for the laborers. They have not been able to get rights, and only 10% of the firms are uh, are there are there within the ambit of labor laws, because these labor laws are applicable only in the organized sector. And most of the laborers in India are falling under the category of disorganized labor. So that is why the government of India has come with come forward to come forward to enact the code of labor laws which has 4 labor laws, pays act, pays code, industrial relation code, social security code, and labor welfare and safety code. So these have been enacted by the parliament, and they have to be implemented as yet. But I will not say much about the labor laws, because I do not want to stand between you and Sanjay Chadha. He is also there, and he will also enlighten us, because he has uh, contested several labor cases. So I hand over the mic to Zainab, and I again welcome the participants, the paper presenters, that despite this pandemic, they have prepared wonderful papers. I have seen myself the papers, and they will enlighten us further on the applicability of labor laws.
Thank you so much, sir. I would like to enlighten you all about Dr. Vipin Malhotra, sir. Sir has been an international scholar in foreign policy, human rights, and disability studies. He has pursued his LLM and PhD and has received the Media Award in Innovative Education 2017. He has presented various papers in international and national seminars. Sir has organized various national conferences throughout his career. He has been frequently invited as a resource person in the field of political science, human rights, and disability laws. Currently, Sir is an associate professor at Sri Aurobindo College, Delhi University, and an honorary director of research and publications of BSK Legal. He was also the vice president of Staff Association of Sri Aurobindo College. Sir is the joint secretary of National Association for the Blind Delhi. He will be chairing the second session. The theme of the session is a holistic approach to labor rights in international scenario. Now, so do we have BT Call sir here with us?
Zainab, I have already spoken, and thanks for the introduction. Professor BT Call has joined.
Yes, sir, we have him here with us.
Uh, Professor BT Call has joined.
Yes, sir, he's here.
Oh, okay. So just introduce, sir. We welcome you.
Thank you very much.
It is a real privilege to have you here, Professor Cole. I must tell you that he is, my mentor, my guide, and if I could take some liberty to say that he is my friend also. He is such a wonderful human being who has been fighting for the cause of labor rights. He has taught us labor rights, labor law, and over the time you will yourself realize that how within few minutes he gets attached to his researchers, and he becomes so friendly that you will chase him for knowledge in time to come. So I would like that Zena please introduce and welcome Professor BT Cole.
Yes, sir. We have here with us Professor Dr. B.T. Kaul, sir. Sir obtained his LLB, LLM, and PhD degrees in law from Delhi University. He was a Foreign Commonwealth Fellow at London School of Economics, from where he earned his second LLM degree. Sir is a true example of excellence. He is the senior advocate of Supreme Court. He has also been the chairperson of Delhi Judicial Academy for consecutive 4 years, where he gave a new impetus to judicial education and training at Delhi Judicial Academy by improving quality and quantity of the programs for judges and other stakeholders. Sir has taught students at Faculty of Law DU for 9 years. He has contributed to the labor law literature by writing annual surveys in the area of labor management relations for more than 3 decades, and has also contributed a number of other writings in the area of labor law and criminal law in various leading legal journals and books. We are very happy to have you here with us, sir. And
Thank you.
Sir will be chairing the first session, where the theme of the first session is labor laws, pandemic, and constitution. I request Sir to please address the gathering.
Well, it's a day which we celebrate as a International Labor Day, that is May 1. And why we celebrate it is because it was a great battle fought. In fact, we would say that it was a great revolution that was brought by the workers across the world uh, to have just conditions of service, and also the exploitation that they were subjected to due to industrialization. And May 1, 1886, that was the first time that workers across the world combined against the arbitrary conditions of services which were inhumane conditions of services. Therefore, you can see the trials and tribulations that the workers across the world had to undergo to earn what we call as just and human conditions of working conditions. Labor is no more a commodity. They are people with human uh, dignity. They are the people with aspirations. They are the people with wants and desires, and they have been given due place in the Constitution of India also. When the Constitution of India was being drafted, Gandhiji's slogan that workers are partners in the production process and therefore must also be partners in sharing the profits of the concern or the industrial establishment, to some extent got reflected in the two chapters of the Constitution of India, that is Fundamental Rights chapter and Directive Principles of State Policy. If you look at Fundamental Rights chapter, you find in Article 19 two very important rights that the workers have earned over the period of time in the form of fundamental rights is right to form association, right to freedom of speech and expression. When workers are not able to get better conditions of service, they exercise their freedom of speech. They also voice their grievances. They have a right to peaceably demonstrate. And these are, of course, not absolute rights, but these are what we call as qualified rights. There are reasonable restrictions on these rights. Then you have, at the same time, recognition of the right of the employer to carry on trade or business. And right to carry on trade or business is not a fundamental right in absolute sense of the term. In fact, in some of the judgments of the Supreme Court, if you go through, I remember two cases of the Supreme Court. One was Edward Mills versus State of Ajmer, and second was Vijay Cotton Mills versus State of Ajmer, AIR 1955, Supreme Court 25 and 32 respectively, where the Supreme Court was dealing with the constitutional validity of the Minimum Wages Act 1948. The employers would contend that you are forcing them to pay wages which they cannot afford to pay, and therefore you are making inroads on their fundamental right to carry on trade or business. The court said right to carry on trade or business is not a absolute right. It is subject to the reasonable restrictions, and payment of minimum wage is a reasonable restriction. If an employer cannot pay minimum wage, he has no right to exist. And if he is so important or his establishment is so important, then in that case, the state can take over. And unless you pay minimum wages, you have no right to exist. Now, these are, you can see the starting points when, the Constitution of India came into force and Supreme Court was called upon to look at the constitutional validity of many legislations. Now you have also the directive principles of state policy. In the directive principles of state policy, you have various, obligations on the state, humane and just conditions of service. You have the fundamental right of the children against exploitation. You have a fundamental right against begar, if you look at Article 23 of the Constitution. Now, these are the very important rights which the workers have across the world earned because of their hard work, trials and tribulations that they have undergone, and the big war that they have fought for their rights. Now, in recent times, you must have seen that COVID-19 brought disaster in the form of workers had to migrate from their homes, from their workplaces, and they had no transportation facility, they had no livelihood, they had no food to eat. And if we could not provide them these things, I think we failed in our obligation towards these people. Now we are again faced with another situation of again COVID-19. We have now again lockdowns. We have again the miseries. People are suffering. They have no food. They have no livelihood. They have no. Now, therefore, the subject that we have decided to choose today is most important subject, and in fact, we must on this day, May 1, 2020. This is a Labor Day which came to be celebrated in India from 1923. It is a day on which we must ponder over these issues. We must see how the government has to recast its policies, frame new laws, come out with new challenges that COVID-19 has posed. And if now work from home has become the norm, therefore we'll have to evolve a new jurisprudence to deal with the rights of the workers, rights of the people who are employees of the organizations, whether we are talking about service industry or we are talking about other industries. It is a new challenge to the whole world, and I'm sure today's deliberations will be very important deliberations and a great contribution to give a way forward to deal with the subject. Now, you must have already come to know that government is thinking of bringing 4 codes: code on industrial relations, code on wages, code on social security, code on safety and welfare. I think the change that has taken place in 1 year, this 1 year, because of the COVID-19 situation, in my opinion, these all 4 codes require a relook, keeping in view the challenges that COVID-19 has brought to the whole world. And therefore, I think today's deliberations, I hope and trust, will be in the best direction to evolve a new jurisprudence where we are able to protect the rights of the workers, enhance the rights of the workers, and empower them with a new bundle of rights that they may require to meet the situation, but at the same time to see how the national economy can be revived, how the employers can also contribute and are able to get reasonable profits on the investments that they make. Therefore, it is a multi-party concerns that have to be addressed, and I'm sure the deliberations that are going to take place during the course of the day will be very wonderful deliberations, which will be, in fact, giving solutions to some of these problems. Thank you very much.
Thank you so much, sir. You're truly a motivation for all of us. It's high time now. I think we'll be starting with the first session, where the theme is labor laws, pandemic, and constitution. And Professor Dr. B.T. Kaul sir will be chairing. I would like to confirm, is Muskan Bansal here? Do we have Miss Muskan Bansal?
The first session is the session 1. Am I right?
Yes, sir. Yes, sir.
It is labor laws, pandemic, and constitution. And we have Mr. Bansal.
Yes, sir. I think will not be able to join us today.
Madam Bansal, Mr. Bansal, and Mr. Bajaj, Nidhi Bajaj. Madam Nidhi Bajaj, Yesh Chikara, and Mr. Chandar Chattopadhyay. Who is starting first?
So we have Muskan Bansal, but I think she is not here right now due to maybe she has some emergency. Do we have Raghav Bansal, Mr. Raghav Bansal here? Mr. Raghav Bansal, are you here?
Jenna, she has backed out.
Okay. And Nidhi Bajaj, Miss Nidhi Bajaj, is she here?
Yes, ma'am.
Yes,
Yeah.
Please start.
Yeah, she's going to present on labor reforms and specifically analyzing the Code on Wages 2019, which has already been passed by the Parliament, and I think the date for coming into force has yet to be notified. And I think this is a consolidation of all the wage laws together. And I think it's a nice area on which we would like to hear from the main speaker.
Ma'am, you may please start.
Okay, can I please request Mr. Jyoti Prakash? I forwarded my PPT to him. Can you please share it?
Yes, yes. Why don't you introduce the speaker first?
Sure, sir. We have Miss Nidhi Bajaj. She's a student of Guru Nanak Dev University, Amritsar, Punjab, and she'll be presenting.
Come, Madam Nidhi.
Nidhi, is
So
it
please,
visual to you? Is it visual to you, Nidhi?
no, it is not.
Just a
I can
minute.
see your screen, but I cannot see the PPT.
Okay.
We can also not see it. Yeah, now it is visible. Can you slightly increase the font? Yeah, it's fine.
Yes, now it's visible.
Yes.
Good morning, everyone.
Yeah.
I'm
Good.
Nidhi Bajaj, a fourth year BLLB student from Guru Nanak Dev University, Amritsar, Punjab. And I feel very grateful to be given this opportunity to present my research paper on this platform. So the title of my research paper is Labor Reforms Analyzing the Code on Wages 2019. So I will be talking about labor law reforms with prime focus on the Code on Wages 2019. The object or my motive today is to create awareness about the provisions of the code. I will talk about the code in the backdrop of existing wage related legislations and will provide answers to the questions like what is the object and significance of the code? What are the new provisions? How is it different from the existing wage related legislations? Are there any loopholes in the new Code on Wages 2019? If yes, then what is the way forward? As for a little background, we all know that labor is considered as the backbone of our country's economy. However, due to various reasons, labor has also been one of the most vulnerable sections of the society. Even recently, we all witnessed the miserable plight of the migrant workers during the initial stages of the lockdown. It is important to note here that labor laws fall under the concurrent list under 7th schedule of the Indian Constitution. And so, there has been a plethora of laws enacted by center and states as well regulating the labor and industrial relations. But these laws have created confusion and conflict and have somehow failed to protect the rights of the workers and promote the ease of doing business. This is also because many of these laws are archaic because they have been enacted in the pre independence period. For instance, the Industrial Disputes Act 1947, the Workmen's Compensation Act of 1923, or the Trade Union Act of 1926, to name a few. Also, the pace of amendment in these laws has been very slow until liberalization came in 1999. These laws primarily dealt with the manufacturing sector and regulated the organized workforce, whereas the service sector and the unorganized workers were given the backseat. Also, according to the Global Competitiveness Report 2019, India was ranked 128th on the labor index, and this report was issued by the World Economic Forum. Thus, to improve its position on the international front, to ensure decent work environment for workers, to promote the ease of doing business, and to fulfill its mission of making India a manufacturing hub in line with our Make in India mission, labor reforms were the dire need of the hour. Next slide, please. Yes, so the background of the labor law reforms. The Second National Commission on Labor was set up in 1999 after a gap of about 60 70 years, and it submitted its report in June 2020. The commission was established or set up under the chairmanship of Mr. Ravindra Verma, and it recommended the amalgamation of the existing labor laws in four groups. These recommendations were being accepted, and the following four labor codes were enacted, namely the Code on Wages 2019, the Occupational Safety, Health and Working Conditions Code 2020, the Industrial Relations Code 2020, and the Code on Social Security 2020. Now, these four codes seek to amalgamate, simplify, rationalize, update, and improve the labor laws with a view to bring about more accountability, responsibility on the part of employers, and maintain industrial peace and protect the rights of the laborers. Next slide, please. Now, the Code on Wages 2019 was for the first time introduced in the Lok Sabha in August 2017. However, then it was being referred to the Parliamentary Standing Committee, and about 24 recommendations were being given by the committee, out of which about 17 to 18 recommendations were accepted. However, the code could not be passed at that time because of the dissolution of the 16th Lok Sabha. In July 2019, it was reintroduced in the Lok Sabha by Mr. Santosh Gangwar, who is the Labour Minister, and thereafter it was passed by Lok Sabha and Rajya Sabha as well and received presidential assent on 8th August 2019. In July 2020, the draft rules under the code have also been published. Next slide, please. So, what is the object and significance of the code? Now, whenever we want to understand the vision behind a statute, we look at its preamble. So, the preamble of the Code on Wages 2019 provides that the code seeks to amend and consolidate the laws relating to wages and bonus and related matters. Now, the object of this law or its significance is to simplify, amalgamate, and update the complex provisions of the wage related legislations. It provides for timely payment of wages to employees, irrespective of any wage ceiling. It simplifies the criterion to fix minimum wage and provides a uniform definition of the terms such as wages, employee, workers. In the earlier laws, these definitions, for instance, the definition of employee has been provided in 4 to 5 or 6 laws, and so it created a lot of confusion. So, this law provides a uniform definition of these various terms. Also, the digital mode of payment have been introduced. E-inspection mechanism has also been introduced under the code under its draft rules. Now, the more important thing to note here is that the Code on the Wages 2019 subsumes or rather repeals the four important wage-related legislations that are the Payment of Wages Act 1936, Minimum Wages Act of 1948, the Payment of Bonus Act 1965, and the Equal Remuneration Act of 1965. Next slide, please. So I'll be dealing with the features of the code in brief now. So first of all, the scheme and applicability of the code. The code on wages is divided into 69 sections, which are further divided into 9 chapters. It extends to the whole of India. So it is very important to mention here that the prevailing labor laws have contradictory provisions, which they have contradictory applicability provisions, which led to difficulties in their enforcement and implementation. However, the wage code of 2019, provides uniform applicability, and it clearly lays down the areas where it would not apply. Next slide, please. So as you can see here, this is a comparison on the existing wage laws and the Code on Wages 2019. For instance, in the Minimum Wages Act 1948, it is being provided that the provisions relating to minimum wages, minimum wages are to be fixed by the state governments for scheduled employments with more than 1,000 employees in the state. Whereas the code provides that minimum wages will be paid to all employees. Also, the Payment of Wages Act 1936, it applies to employees whose wages do not exceed rupees 24,000 per month. Whereas the code provides that the provisions relating to the payment of wages will apply to all employees.
You're not audible. We can't hear you.
Am I now audible?
No, now, yeah. Right.
Okay.
Good.
Next slide, please. Yes. So I'll be dealing with the definitions that are being provided in the code, not all of them, but the most important according to me. Now, first of all, the definition of employee. Now, it is more or less similar, however, more or less similar to the earlier laws. However, the most important thing or the innovation that has been introduced is that it also includes a person declared to be an employee by the appropriate government. And the definition of employee, it has been extended to all categories of employees, irrespective of any wage threshold. Second is the definition of worker. Now, the definition of worker is also similar, but the working journalists and the sale promotion employees are also considered as workers under the definition. Next slide, please. So these are the exceptions where a person will not be considered as a worker. For that is when he is subject to the Air Force Act or the Army Act. When he is he's employed in a supervisory capacity, drawing a salary of more than 15,000. He is employed in a managerial or administrative capacity, etc. So what is the difference between employee and workman according to the code? The code distinguishes between an employee and a worker. An employee includes all employees in all categories of employees, including the managers, the supervisory staff, and the administrative staff. But the definition of worker, it specifically excludes the managerial and administrative staff and the supervisors drawing salaries of more than 15,000 rupees. Next slide, please. Now, the definition of employer has been, the term employer has been defined in a very clear and unambiguous manner. And the definition is, yes, it is similar to the earlier laws, but the most important innovation that has been added is that a contractor and legal representatives of a deceased employer have also been included in the definition of employer. The code has equated the contractor with that of an employer, and he too will be responsible for the implementation of the provisions of the code. Now, this will go a long way in protecting the interests of the workers and imposing liability on the errant employers or the contractors. Also, the code provides that the burden of proof is on the employer. For instance, if a claim is filed by a worker, say a worker, that the wages are not being paid to me, the bonus is not paid to me, then the burden of proof the burden of proof to show that yes, the wages have been paid is on the employer. He is to prove that he is innocent. Also, section 63 provides that in case someone else is the real offender, the employer can bring him to the notice of the court and relieve himself of his liability. Next slide, please. Now, the code contains a chapter on the prohibition of discrimination on the ground of gender. Now, this gives effect to the Article 14 of our Constitution, which incorporates the principle of equality, and also the International Labour Organization's Equal Remuneration Convention of 1951, which India has also ratified. So, Section 3 of the code provides that there will be no discrimination among employees on the basis of gender or sex in the matters relating to the payment of wages, conditions of recruitment, employment, in respect of the same or similar work done by the employee. The expression same or similar work has also been defined in the definition clause in a very clear manner. And the only exception or the exemption that is envisaged by the court is when the employment of women is itself barred by some law for the time being in force. And you can also see the distinction between the Equal Remuneration Act provisions and the provisions of the Code on Wages 2019. Next slide, please. Now, next comes the chapter of minimum wages. Now, first of all, it has to be noted that the Minimum Wages Act 1948 listed the employments wherein the minimum wages are to be paid to the employees. Now, the employments that have been listed therein contain mainly the organized sector and certain categories of the unorganized workers. So, a large proportion of the unorganized workforce is excluded from the operation of the act. And it is also very pertinent to note that it is being said by the report of the Ministry of Labor that 92% of the workforce is unorganized in India. So the code, on the other hand, it universalizes the concept of minimum wage and makes it applicable to all employments, be it organized.
Yes.
So I think there's some network issue.
Some voice issue.
a minimum wage rate that is less than the floor wage. And in case the existing rate is more than the floor wage, then the appropriate government cannot reduce that wage rate. Next slide, please. So, what is the criterion for fixation of minimum wages? A 3-point criterion has been provided in the code, which shall include primarily the skill required. What is the skill required for the job? Arduousness of work. For instance, what is the temperature of the place, or is it a hazardous occupation? And the geographical relation. Now, this is the 3-point criteria for the fixation of minimum wages. The code also provides a procedure for the fixing and revision of the minimum wages. It provides two methods. That is, one is the committee method, and second is the notification method for the fixation and revision of wages. Also, a similar provision like the earlier act has also been included. That is, the code fixes a time period of not exceeding 5 years for the review and revision of the minimum wage rate. Section 10 of the code is also very important. It provides that an employee who works for less than the requisite number of hours that are required to constitute a normal working day, he shall be entitled to receive the wages for the full day. However, this shall not be the case when the failure to work is due to his own unwillingness and not because of some omission of the employer. Now, the code also clearly points out, and under the rules, it has also been pointed out that what is the number of hours that will constitute a normal working day, what shall be the period of rest, and the code also fixes minimum wage for overtime work at an overtime rate that shall be twice than the normal rate of wages. Next slide, please. Now, next we come to the chapter on payment of wages in the code. Now, the existing Payment of Wages Act 1936, it applies to only those employees whose monthly wages are less than or equal to rupees 24,000. But the code fixes strict responsibility on the employers for timely payment of wages to all the employees, and the threshold of this 24,000 has been removed. Now, there is the employer has to pay timely wages to the workers, irrespective of any threshold. Moreover, it is provided that an employee who is dismissed or say retrenched or resigns or becomes unemployed has to be paid his wages within 2 working days. The mode of payment of wages is also very clearly being mentioned in the code. Digital mode of payment has also been given recognition explicitly by the code. Fixation of wage period is also being mentioned, that it can be on the daily basis, it can be fortnightly, it can be weekly or monthly, but it shall not be more than 1 month. Time limit for paying wages. Now, when will the wages be? What is the time limit when the wages will be paid? So, a worker that is engaged on daily basis has to be paid on the end of the shift, weekly basis, on the working day, on the last working day of the week. That is, if Sunday is a holiday, then he has to be paid on Saturday. Then fortnight basis before the end of the second day after the end of the fortnight, that is 17th day, and monthly basis before the expiry of the 7th day of the succeeding month. Next slide, please. Now, coming to the provisions relating to payment of bonus. So, the provisions relating to payment of bonus are similar to the Payment of Bonus Act 1965. However, in the Payment of Bonus Act, we had a limit of, I guess, 20,000. But this limit has been removed, but it has also been provided that the code on wages provisions of the payment of bonus will apply to those employees whose wages do not exceed a specific monthly amount. Now, the specific monthly amount is to be decided. The provisions, now employee has to be entitled for bonus. He has to put in at least 30 days of work in an accounting year to become eligible for bonus. And the provisions shall apply to only those establishments where 20 or more persons are employed or were employed during any accounting year. Now, there are grounds for disqualification of bonus, such as righteous behavior, etc. But one additional ground for the disqualification from bonus has been introduced by the code, that is conviction for sexual harassment. Also, Section 41 provides a comprehensive list where the provisions of the payment of bonus will not apply, such as the employees of LIC, employees of the central public sector undertakings, etc. Next slide, please. Now, coming to the other important provisions of the code. Now, the code has introduced a uniform mechanism for adjudication of claims. A claim application can be filed to the authority that is being appointed by the appropriate government. By whom it can be filed? It can be filed by a concerned employee, by a registered trade union, or by the inspector cum facilitator. The code provides a statutory right to appeal in all the matters relating to wages. Also, as per Section 57 of the code, the jurisdiction of the courts is being barred for any suit relating to recovery of minimum wages, any deduction from wages, or discrimination in wages and payment of bonus. The code also envisages a robust inspection mechanism with the provision for appointment of an inspector cum facilitator who will perform the functions of not only the examination and inspection of premises but also educational activities and other activities like advising the employer or the workers how to observe or how to follow the provisions of the code. And also the rules talk about the electronic inspection mechanism. Next slide, please. So coming to the critical analysis of the code. So, according now, the code has catered to the long-standing demand of labor reforms in the country. That is true, and it has made a decent attempt to revolutionize the employer-employee relationship. However, it has also received its fair share of criticism. One of the major grounds is the absence of specific provisions for the gig workers. Now, gig workers, despite enjoying the flexibility and freedom of choosing their work hours, they are poorly paid, and because they have no specific legal provisions that deal with them for the protection of their rights. Now, the Honorable Supreme Court in the recent case in 2019 of the Godavari Garments case, it has held that for the purposes of EPF Act, the women who work from home, they stitch the clothes using their own machines, but using the material that was being provided by the factory. They will be considered as the employees of the company who engaged them, even in absence of a direct contract between the two. Now, the judgment holds significant value for the gig economy because it rejects the idea that for an employer employee relationship to exist, the employee should be working at the employer's premises. Now, gig workers are usually paid on the basis of the tasks performed. Thus, the question of the fixation of minimum wages for these workers should have been, according to me, it should have been explicitly and clearly and specifically addressed by the court, keeping in mind the peculiar nature of the work done by them. And in absence of these provisions, we have to look towards the court for giving the wider interpretation to the provisions of the code or towards the state government for ensuring the effective implementation of the code. However, the gig workers can be included under the if the government says or the court provides such an interpretation, they can be included under the definition of employee, where it has been mentioned that the appropriate government may declare a person as an employee. Next slide, please. Other point of criticism that may hamper the right of an aggrieved employee to approach the court, that is regarding the bar of the jurisdiction of the court under section 57. It provides that in the disputes relating to the wages wherein they shall be dealt with by a special quasi-judicial authority that is being appointed by the government. Now, such a provision may ensure accessibility to speedy resolution, but it does have a potential to hamper the right of the aggrieved employee to approach the court. Next slide, please. So, in conclusion, I'd like to say that the Code on Wages is an effective piece of legislation that is aimed at harmonizing and reconciling the existing wage-related legislations. The codification of the definition of employees' wages, establishment, it has brought the much-needed uniformity, and the adoption of technology in the payment of wages or the inspection mechanism is also in line with our digital mission. The code has established an effective dispute redressal mechanism that will lead to speedy resolution of wage related disputes, thereby promoting the ease of doing business on one hand and the rights of the workers on the other. In short, it can be said that the code on wages it makes an attempt to bring about a balance between the interests of labor and the interests of the employer. However, it goes without saying that in light of the work from home that is the trend of the day and also being mentioned by BT Call sir, that yes, the code needs a relook, and these provisions must be added with regard to the work from home or the gig workers, etc. Thank you so much.
Very well presented, and the object of this code explained thoroughly. In fact, there were two National Commission of Labor. First was the Gajendra Gadkar Committee report of 1969, which had also suggested that there should be an effort to harmonize the definitions in various legislations. And then was the Verma Committee report, which was the second National Labour Commission report, which of course talked about harmonizing the laws by giving them in the shape of a code so that there is no multiplicity of legislations, and a subject matter was having a uniform definition. Like she said to you, that Code on Wages is a consolidation of the law relating to Payment of Wages Act 1936, Minimum Wages Act 1948, the Payment of Bonus Act 1965, and Equal Remuneration Act of 1976. Now, this is an attempt to give a uniform definitions, uniform machinery, uniform implementation. But as she said rightly, that these codes were drafted when COVID-19 challenges were not faced by the nation. But in view of the challenges that have been posed by COVID-19 situation, these also, like she was referring to the gig workers, she has also referred to the difficulties that are going to be faced when we have work from home. But then she was right when she made a distinction between employee and worker. Now, employee is a wider concept, while as worker is not that wide concept. But one thing which is good about this code is that it talks about minimum wage, which is universalized minimum wage, and it does not make a distinction between scheduled and unscheduled industry. So there are concerns which I think she has very nicely brought out, and I think with a student at this stage dealing with a subject of such a magnitude and dealing with the subject of wage code is itself a very beautiful attempt, which I think she has made efforts to critically analyze. I think it's a very good effort on the part of the Nidhi. Very good, very well done. I think we have next speaker is.
Thank you, Ms. Nidhi Bajaj. Thank you,
Thank
sir.
you very much.
So
Yeah, yeah.
next we have Yash Shikara. He's a student at National Law University, Orissa, and he'll be presenting on suspension of labor laws.
This is a very important topic in view of the fact. I will comment on it in the later part of it, but I was very keen to deal with this part of it because efforts are on the part of the various states to suspend the rights of the workers under various legislation. In fact, a recent judgment of the Supreme Court, I do not know whether she is going to refer to that or not, is that Gujarat Mazdoor Sangh, where Justice Chandrachud has given a very beautiful judgment where they had suspended certain provisions of the Factories Act by exercising the powers under Section 5 of the Factories Act, which of course did not give the powers because they gave powers only in emergency situation, and the Supreme Court said these are not internal emergency situations. So therefore, I think that's an area which is a very beautiful area, a very important area in today's when every state is trying to play with the rights of the workers, deny the rights to the workers in the guise of globalization and ease of doing work, and taking the plea that what is happening is that to revive the economy, workers will have to compromise on their rights, which I think is something which is unacceptable. I'm sure he's going to deal with all these aspects in the matter. Thank you very much.
Yes, so before I begin, let's just give me a second, I'll present my screen. Is my screen visible?
Yes, sir, it is.
Thank you very much. Good morning, everyone. I hope everyone is doing good in these trying times. Please pardon me if I'm not audible or if I be heard coughing because I'm not that completely well.
Dana, we have not introduced the speaker.
Yeah.
So I told about him. He's a student at National Law University of Orissa. And that's it.
Orissa.
Yes, the National Law University of Orissa.
Yeah, I'm a second year student of National Law University Odisha.
Very good, very good.
So please pardon me if I'm not audible or if I may be heard coughing because I'm not that completely well. On a positive note, let's just, since we are using this technology to interact with each other in these trying times, let's just consider ourselves the forerunners of this changing world. First of all, I'd like to give really thanks for the opportunity to present my paper here. Before I begin, I'll just like to mention that since Professor mentioned that suspension of labor laws is a really important area to discuss at this point of time, since we are in a very difficult situations and the states like UP has suspended majority of the labor laws. So let's just see what is the cause of concern. I'll just make my presentation on full screen if that's visible. 1 second. Yeah. So yeah. So what is the cause of concern in these trying times? So we have seen that on May 6, 2020, the government of Uttar Pradesh has suspended majority of the labor laws. By the term majority, I mean 35 out of 38 labor laws have been suspended by the Uttar Pradesh government. A similar step, though to a smaller extent, is being taken by the state of Gujarat as well as Madhya Pradesh as well. So, what is the cause of concern? Why the government did this? So, the rationale provided by the government of these states was that it would help the economy to revive from the economic slowdown due to the COVID-19 pandemic. We will analyze these reasons, whether the government has suspended these labor laws, the reasons which were given by the government, whether they stand true or not, what are the various conditions, what are the implications. We'll discuss all
Just
these
a
points
second,
later.
speaker. I just want to confirm, do we have Sir here in the meeting? Because he's not visible. BT call, Sir? I think he has left. Okay, yeah. Sir,
Yes. Yeah.
you may continue.
I'm here.
Okay, sir.
So the rationale provided by the government of these states was that it would help the economy to revive from the economic slowdown due to the COVID-19 pandemic. We will analyze these reasons. We will see what are the implications and whether these reasons hold true or not. What are the various implications of those? So the result of such action was that there were a lot of workers on the street. So I'll just like to highlight this point. There were a lot of workers on the street because of the pandemic. We are very well aware. We can see the picture as well. Because of the pandemic and the lockdown, all such things happens. It hit the workers at a time when they were already suffering from the pandemic. The social security measures which were made to protect the workers were now being called the ones to prevent the interest of these workers. So we can see how ironic it is. So the labor laws which were made to protect the workers are now being called that they are hampering the workers' right. So we will see how ironic and how contrasting these statements are made by the government. So first of all, let us analyze the reasons for suspending the labor laws. The government has suspended the labor laws. So what are the reasons they gave? First major reasons which was given by the Uttar Pradesh government, I will majorly focus on Uttar Pradesh government, which was that these labor law reforms would provide relief to the employers who were complaining about the labor shortage amid the pandemic. So there were labor shortage amid the pandemic. So the government thought that if we suspend the labor laws, it will be able to overcome these difficulties. The second reason which was given by the government was that the various firms which were seeking to move their production out of China because of the pandemic would find a way in India. So the government thought that if they suspend the labor laws, they will be able to attract the firms which were moving out of China. The third reason was it will help the industries which were struggling to sustain economic slowdown amid the pandemic. So there was, as we are very well aware, that the economic slowdown occurred due to the pandemic. And so if we suspend the labor laws, it will be able to generate employment as well as able to overcome economic slowdown. These were the statements made by the government. The fourth reason was through these reforms, the employers would be able to protect the existing jobs as well as create new jobs for the returning migrants. So the government thought that suspending the labor laws will be able to create employment. So I'll just critically analyze these reasons, whether these reasons hold true, whether there are evidence that states that these reasons could be stated and would be able to generate the things as they are being claimed. The aim of this paper is the author through this paper would highlight that these ordinances to suspend labor laws are unconstitutional by being violated of the fundamental rights. Fundamental rights, I must tell you, these are available to everyone and they are being fundamental, means they are the soul of the constitution. Affecting these will make the ordinances unconstitutional. And by being the country's commitment to international labor law conventions, there are various conventions by the ILO and we are committed to those obligations, and hence if these are being violated, it would result in a country it would be against the country's commitment. The author will critically analyze the reasons for suspending these laws and would establish that suspension of these codes would have a large socio-economic impact on the lives of laborers in these testing times and would do more harm than the proposed good. I'd like to re-emphasize that would do more harm than the proposed good. So the issue at hand, I just like to mention a very keen author, Naomi Klein, once mentioned. I just like to re-emphasize here it. In the moment of crisis, people are willing to hand over a great deal of power to anyone who claims to have a magic cure. I'd just like to emphasize people are willing to hand over a great deal of power to anyone who claims to have a magic cure. The recent state of disaster has translated into such a spectacular profits that many people around the world have come to the same conclusion. I'd like to repeat here that the rich and the powerful must be deliberately causing the catastrophe so that they can exploit them. This statement does not need any further emphasis because Naomi Klein, in her Shock Doctrine, a very famous book, has mentioned this. And it could be said that the rich and powerful must be deliberately causing this catastrophe so that they can exploit them. So the issue at hand, I just like to emphasize, Sarkar and Dakin in 2011, a famous researchers who has worked really well in the area of labor laws, using the leximetric data on Indian labor laws between the period 1970 to 2006, have instituted that the existence of labor laws has resulted in low unemployment. See, it's completely contrasting to the thing that the government said. Government said that the suspension of labor laws will result in increase in employment, but researchers has said that the existence of labor laws would result in low unemployment. Similarly, the another researchers, brilliant researchers Upadhyay and Kumar, and in 2017 did not find any evidence which established that previous labor law reforms in Rajasthan and other states have succeeded in attracting investment and boosting investment. So they don't find any evidence that the labor law reforms would create investment. So again, it's a contrasting thing to what the government mentioned. The Constitution of India provides innumerable rights to safeguard and protect the interests of the workers. Part 3, Fundamental Rights, as Professor mentioned. Part 4, Directive Principle of State Policy, provides for various rights such as right to life, which includes right to livelihood as well. Right to equality, which means that the women would not be treated differently from males in terms of wages. Freedom to form association, again, as Professor mentioned. Protection from exploitation. The state government, by suspending these labor laws, has stepped towards violating these fundamental rights of laborers and its commitment towards the International Labor Law Convention. So now I'd like to talk about employment. The government mentioned that the suspension of labor laws will create employment. Let's see how this stands. As I mentioned, there is no evidence to point that more labor-friendly regulation will lead to unemployment. There are no evidence which states that. And industrial stagnation, as mentioned by Upadhyay and Kumar, Sarkar and Prabhajit and Dakin. There are a lot of researchers who mentioned. The figure you are seeing here, I'd like to give a background of this. Between the period 2014 and 2016, there were various changes which were brought in the labor laws by the state like Rajasthan, Gujarat, Madhya Pradesh, Maharashtra. So they made various labor law reforms. Various proposals were made to dilute the labor laws. However, they were not fully suspended as they are suspended now. The data tells that the state like Gujarat, Madhya Pradesh, and Rajasthan, after they have diluted the labor laws, are neither able to produce more written contracts nor able to perform the protecting the social security measures of these workers. If you see the figures, we see the Rajasthan, 85% not having a written contract. So this, what is the benefit of diluting the labor laws if the average of all India is better than the Rajasthan after diluting the labor laws, right? So similarly, if we see the data from the year 2015 to 2017, that reveals that state which had presently suspended the labor laws, which is Uttar Pradesh, Madhya Pradesh, had witnessed the rise in employment level in the past. So if there is increase in employment in the past where there was presence of labor laws, so why there was a need of suspending the laws? If we observe that the Employment in Factories Act 1948 for Uttar Pradesh, we saw the rise in employment from the year 2015 to 2017. This depicts that when these labor laws were active, they had no decrease in employment level. That means when these labor laws were there was no decrease in employment level. So what was the need that the government need to suspend the labor laws and by thinking that this will increase employment? Because there are no evidence which states that more labor-friendly regulation would result in unemployment. We see the COVID-19 pandemic has largely hit the migrant workers and laborers. According to the study of Azim Premji University, but the Center for Sustainable Employment, two-thirds of the survey respondent, I like to re-emphasize here, two-thirds of the survey respondent had reported a loss in employment. Means the total survey among the number of people, 2/3 of them has lost their employment. Workers are toiling hard to make their both and meet in such in adverse circumstances. And suspending these labor laws on the pretext that the framework is preventing them from receiving a dignified life is disheartening. The laws which were made to prevent exploitation and ensure social security are now being considered responsible for their plight. If I like to mention that, as Professor mentioned, that a great battle was fought to achieve what the rights were given to the workers. And if at present point of time, these laws were made to prevent exploitation, and now they are being said that they are the reason of the plight of the workers. It's just contrasting statement and ironic. The reasons for to overcome hunger in this adverse condition will never attribute to giving the safeguards, not at least until they are backed by considerable data, which unfortunately was not presented by the government. Second thing, the main contention of the government was that it would be able to attract the firms moving out of China. A lot of firms will come to India. It will create employment. Let's see whether labor laws are the main concern. Various researchers had argued that labor laws no longer considered to be the major concern for the foreign firms. So the foreign firms that comes to India are no longer considering labor laws as their primary obstacle. Relaxing the labor laws to lure foreign firms is no longer a promising option. Was the study conducted by the Bruce Noonan Camp Marina Spentanu 2011. Further, the nations with respect to the labor right was found to achieve more foreign direct investment. See, it's contrasting. The nation with which respect labor rights are found to achieve more foreign direct investment. And it's the study in 2011 by the Lindsay. The rigid labor market tends to discourage foreign direct investment. So, as it rightly said, that devil resides in detail. So let's just see the figures, and these figures are not stated by anything but the World Bank Enterprises Survey. Let's just see whether they create employment or not. Less than 5%. I would like to emphasize less than 5%. That is only 4.9% of the firms believe that labor regulation to be a primary obstacle. That is only 4.9% of the firms believe that the labor regulation is an obstacle for them. And if we see Uttar Pradesh government, which has suspended 35 out of 38 labor laws, which has suspended, that only 2%, the state of Uttar Pradesh, which has recently suspended the majority of labor laws, shows that 2% of the firms in the state consider labor regulation as a primary issue. Only 2% of the firms believe that labor regulation is a primary issue for them. In Uttar Pradesh, 34%, such a large number of people, a large number of firms, 34%, believe that corruption is a primary obstacle. So at a time when the government should deal with the corruption, they are dealing with only 2% of the thing. They are ignoring 34% of the firms that believe corruption is a primary obstacle. Another survey which was conducted by Niti Aayog and IIDFC Institute states that the firms with employees less than 50 and firms with employees more than 99 reported that labor regulation is not an obstacle for them. They say that labor regulation does not have any obstacle, does not concern them for the firms with less than 50 and more than 99 employees. So let's just see what is the socio-economic impact of suspension of labor laws. I'd like to mention what US President, 34th US President once mentioned. He mentioned, should any political party attempt to abolish social security, unemployment insurance, eliminate labor laws, and farm programs, would not hear of that party again in our political history. See the contrasting things which are happening at this point of time, and what US President, another democracy, oldest democracy, has mentioned. Should any political party attempt to abolish social securities of the workers, you will not hear of that party again in the political history. But see what is happening at this point of time. The decision of the state government, especially Uttar Pradesh, seemed to expose the workers to exploitation by taking away their legal protection. The act by the state is not only against the fundamental rights of the worker, which I'll explain now, but also against the labor law conventions. Article 21 of the Constitution of India, let me tell you, ordinances by the state does not only prevent the rights of the worker to have a dignified life, but also against their right to work and livelihood. Article 21, which says right to life, in Philothera of judgment of Supreme Court has mentioned That right to life means dignified life, and that consists of the workers as well. So it's just violative of Article 21, the major pillar of the Constitution of India. As Professor mentioned, Article 19(1)(c) of the Constitution of India. Ordinance suspended the Trade Unions Act of 1926. Such an act would prevent the workers to form unions and therefore would be violative of Article 19(1)(c) of the Constitution of India. Article 14 and 39D of the Constitution of India. Suspension of Equal Remuneration Act. The Uttar Pradesh government has suspended this act as well, which provides for equal remuneration to be paid to the women as compared to men would now be ineffective. That means women could be paid less in comparison to the men. This is again a clear violation of Article 14 and Article 39D of the Constitution. Convention number 144, which I was mentioning from the beginning, that International Labour Law Convention. Suspension of industrial dispute acts result in lawlessness and effect allows employers to hire and fire workers at their own wish. It means the employers can hire and fire workers at their own wish. So how can we think that this suspension of labor laws would create employment? The ordinance also stand in violation of International Labour Law Convention, that is Convention number 144, which prevents, that is, to form trade unions, again violative Article 39, Article 19(1)(c). Also, suspension of Minimum Wages Act 1948 would cause severe difficulties to the workers who had already received a large hit because of the pandemic. So we are affecting those people who had already are affected by the most by the pandemic. So we are already making their lives more worse. And it's a battle of great years that we have brought these labor rights. And at this point of time, suspending those will make this country move back several years or maybe decades. So conclusion, I just like to mention that I have through this paper tried to critically analyze the reasons for suspension of labor laws in the country. Further, I have attempted to prove that suspension of labor laws by the state is against the fundamental rights of the workers and therefore would have a large socio-economic impact on the lives of workers. Author has identified that the state government had failed to provide reasons to substantiate the suspension of labor codes would lead to increase in employment. The author argued that such reasoning by the government is flawed and that presence of labor laws would not affect employment levels, or that suspension of labor code would not increase in employment as proposed by the government. Author also tried to prove that the labor regulation does not constitute as a primary obstacle for the foreign firms to invest in India. Many other important issues require attention of the state than labor regulation to attract foreign investment, like corruption. The author has tried to prove that the act of the government to suspend labor laws is unconstitutional and would have a large impact on the lives of workers and would do more harm than the proposed good. Thank you.
Thank you very much, Mr. Yesh. What he has stated is something which is very important, is whether the states can resort to issuance of ordinances and not follow the procedure prescribed by Article 213. You see, as the earlier speaker said, Nidhi said that labor falls in the concurrent list. It's a subject matter on which both state and center can make a law. Now, there are certain states like, Maharashtra, you have Bombay Industrial Relations Act, they have Maharashtra Recognition and Prevention of Unfair Labor Practices Act 1970, but those legislations have been passed with the prior approval of the President of India. Now, when you issue ordinances amending or doing away with the central legislations, you have to follow the procedure prescribed in Article 213 of the Constitution, which I'm sure in UP, this procedure has not been followed. And if they follow this procedure, I'm not sure whether the President is going to give his approval for suspending these ordinances. Now, this is something which is unacceptable because, as we said, we are celebrating today May Day, which is a International Labor Day, and workers across the world have fought for these rights. And these rights from common law right have evolved into human rights and evolved into fundamental rights. And if you take away these rights of the workers, what you are going to do, you are going to bring again back the state theory of laissez-faire, where this was complete exploitation. People were made to work even on starvation wages, and hire and fire was the predominant philosophy of the employer. I'm sure courts will rise to the occasion, matters are pending before the Supreme Court, and I'm sure in some of the cases which are pending before the Supreme Court is going to take a very serious view of these matters, because it is proved by the speaker just now that the argument advanced by the state that this is going to bring revival of the economy, this is going to attract the foreign investment. I think both these arguments are not acceptable, these are not maintainable, they are not tenable. And what is important is you have to wean the workers into the system, you have to care for them, you have to get wholehearted cooperation from them, and you have to ensure that there's an industrial harmony. And if industrial harmony is revived, I'm sure the production is going to be more. And if you are going to have just and humane conditions of work and not play with their fundamental rights, we can revive our economy without resorting to unscrupulous means that the states are trying to resort to. Thank you very much. It was a wonderful presentation. I am sure if you are able to substantiate it with further data, it can be a good paper. Now, who is the next speaker?
So next we have is Mr. Chandra Chattopadhyay.
Yes.
And he's a student at Department of Law, the University of Burdwan, West Bengal. And he'll be presenting on the Exodus of the Plagued Black, a study on the labor rights in India during COVID-19 pandemic.
So please go ahead with your presentation.
Thank you, sir, and good morning, everyone present here. So I'd like to start off by asking if my presentation and the PPT is visible or not.
Yes, very visible.
Yes, very visible. Okay, sir. Thank you so much, sir. I would like to start off with a quotation by Albert Camus in La Peste, which is The Plague. When I had read it, there was a quotation which said, "We tell ourselves that pestilence is a mere bogey of the mind, a bad dream that will pass away, but it doesn't always pass away, and from one bad dream to another, it is men who pass away." So our term, the terminology that we have used in our paper is the plague, and from The Plague by Albert Camus, we have tried to derive the entire idea of the human rights perspective beyond a pandemic and the plague and the plagued life that these migrant workers live. So any greater threat to the democracy of the nation is faced initially by a group of individuals who are situated at the lowest rung of the societal hierarchy. In a world fraught with the highly contagious pandemic virus, the necessary preventive measures were implemented overnight to curb the rapid state of the viral outbreak of COVID-19. 2020 was a nightmare with overnight lockdown imposed on the 24th of March and had drastically changed the life of the migrant workers and laborers in India who were located away from their homes in search of a better livelihood. The idea that the individual migrant laborers who did not know how they would get back to their homes or even procure food for the next few days during this period in time has been effectively termed as the exodus, the movement which definitely aimed at the mass movement of the laborers back to their origin in swarms. The idea of the swarms is initiated with and associated with the insects, and the idea of the laborers being termed as insects is something that we need to think upon. The 21 days were the most horrifying 3 weeks that they did not know what they will return to or how they will feed their families who wait in anticipation back in their homes. The problem is beyond that what is guaranteed to us by the mandates of the welfare state in the directive principles. The migrant laborers do not fall under the ambit of the protection policies of the government or the trade unions in India, and as a result, these illiterate daily wages are often subjected to the violations by the employers in terms of non-payments, underpayments, other forms of injury, only because these are unorganized sectors where they work, and payment is also not regularized according to the guidelines of the Minimum Wages Act 1948. The disparities in the job availability is different in different regions of the country. The calamity is the agricultural crisis, and importantly, the freedom of living and displacement and social mobility are often the factors that has resulted in migrant displacement over time. According to Castles, this mobility is often the result of finding better means of livelihood and in finding avenues to alleviate poverty and improve the living conditions. Better livelihood are also tantamount to better opportunities for their children, better healthcare, better social protection as a whole. This better workforce also ensures a faster economic growth. Surely the government of India's public policy in the initial days were a means to curb the sudden surge in the number of COVID-19 cases, but it definitely had a very negative effect on the migrant interstate laborers. There was an abrupt cutoff of all the resources and the way of conveyance, resulting in a display of poor implementation of the planning. Now, if we're looking at the predicaments, it is imperative to understand that the crowded, huddling, and the mass exodus are schematically one of the greatest ways by which COVID-19 has spread. But it is this class of people who died by suicides, by the disease, by the heat strokes, inability of the primary care, etc. These are all the several other factors that have not been taken into cognizance. Also, we need to see at the statistical data that puts around 12.8 crores of migrant laborers that have been put down because of the wrath of the virus and non-cooperation from the government in terms of giving the necessary utilities to survive the hardest times in 2020. The skilled and the semi-skilled laborers were the ones who returned and tried seeking jobs under several local schemes like Manrega 2005, under the shadow of the Article 41 of the Indian Constitution, where already existing locals had registered, resulting in a chaos and survival for the limited jobs against the several applications for the 100-day work scheme. We are looking at several other factors here. There are social aspects to such migrations and reverse migration. The term of reverse migration is very important in understanding the fate of the migrant movement. The degradation of the mental health affect the sections equally, and on being able to return amidst a viral outbreak, social stigmatization and ostracization were rampant and thereby resulted in further problems for those who managed to come back to find a job or mingle with those whom they thought would support but did not. There is also an important concept in labor economics, which is the corrupted labor bureaucracy. What is the corrupted labor bureaucracy? Now, let us see that there are some governments which have removed the labor laws altogether, as my previous speakers have already said, and for a set period of time, which in turn affected the already existing labor structure that does not ensure a very smooth processing of the rights of the individual laborers. We have to look at PUTR versus Union of India, 1982. The provision in itself has a very constitutional backing, thereby enabling that these laborers who are the victims of a complex market economy and hierarchical autocracy that makes them accept any work to survive are given the basic salary for the same. The question is whether the present government could at all guarantee in the face of the pandemic, the answer to which is no. In a report dated March 31st, 2020, the Ministry of Health and Family Welfare had stressed on the special care for the elderly, the comorbid, the women, the children, that is all sections that are more vulnerable to the crisis. The strange quotient in dealing is a subjective overlooking of the plights of trans women and the queer community, who are also a part of the labor community as well, whose welfare should have been guaranteed under the guidelines by the National Commission for Women that aimed at drawing the attention of the Ministry of Women and Child Development to ensure a sensitive procedure of quarantining lactating pregnant women to prevent infection from mothers to their children, among other things. So is the gender-sensitive goals meant only for the bodily representative of the femalehood and not the transactional who embody a struggle for generations, and more so in such a lockdown phase, especially if they're the migrant laborers, as the case may be? Only the government and the agencies that look after the welfare of the underrepresented can answer that. The Committee on the Labor Welfare, which gave us a definition of the term labor welfare, can be stated as follows. The labor welfare includes such services such as the facilities and amenities as adequate canteen, rest, recreational facilities, things which had not been provided, as you can note, sanitary and medical facilities, arrangement for travel to and from work, and from the accommodation of the workers employed at a distance from their homes, and such other services and amenities which contribute to improve the condition under which the workers are employed. Now, there are some of the factors that the laws that during this time that the laws saw that the development after the independence that aimed at also setting up a provident fund, the insurance, and the other employee benefits for the protection of the interests of these workers. The Factories Act 1922, which had put a limit of 60 hours per week and 11 hours per day for the workers, while the Trade Disputes Act removed the initial rights to protest in case of a deadlock between the employer and the employee. However, these laws never clearly guaranteed what must be the constitutional right and conclusion to such demands of the workers as the situations may be, and therein lies the way to withdraw the basic human rights of these people in these workplaces. The states have, as my friends have said, and I would reiterate, that there are places like Himachal Pradesh, Uttar Pradesh, with the Uttar Pradesh temporary exemption from certain labor laws, Ordinance 2020, Gujarat, are among the places that have suspended the labor laws for a pretty long time. And this has made the workers subject to an inevitable slavery in the name of controlling economic slowdown and industrial growth over time. It is strange how for the major economic hurdles, it is people who are at the lowest rung, who give presently 9 hours a day and 48 hours a week, are sometimes and even more to a life that is beyond unimaginable trauma in the face of the corporate policymakers and government officials. These things must change with time, and with the rightful remuneration and treatment in workplaces with proper associated benefits must be supplemented with. Now we are looking at the textbook case of utter mismanagement. My friend Rakshita will be taking from here, and I'll be getting back with certain statistical data on the same. So Rakshita, can you please take over?
Yeah, so first of all, morning everyone. No presenter already.
Yeah.
I'll be carrying on the same. So, a textbook case of utter mismanagement. The government lagged in providing basic necessities for the survival of the migrant labor who were dying in poverty instead of pandemic. The sudden outbreak of pandemic and unorganized declaration of lockdown adversely affected the weaker section of the Indian economy, making them weakest. They were compelled to leave cities and walk back to their native towns for the survival on barefoot. So, effective step was taken by the government to provide them at least with transport and other facilities so that they could at least get back to their towns safely. Inefficient and ineffective steps were taken by the government, infringing their human rights. Uttar Pradesh, through an ordinance called Uttar Pradesh Temporary Exemption from Certain Labor Laws Ordinances 2020 has suspended 35 out of 38 labor laws for the period of 3 years. The state justified this step on the ground that the economic activities need to get back on the track and industrial investment opportunities need to be created. The Central Indian Trade Union called the move barbarous and told it as encouraging slavery of workers. Dilution of these labor rights, working hours of the laborers was increased from 8 to 12 hours without lawful compensation. Codes, the Occupational Safety, Health and Working Condition Codes 2020, the Industrial Relation Code 2020, and the Code on Social Security 2020. These were the new codes brought by the government, merging 24 central labor laws in a major boost to labor reforms. The National Democratic Alliance government has now merged 29 central laws into 4 codes. In August 2019, Parliament has passed the first of codes, the Wage Code. The Social Security Code proposes a nation Social Security Board which shall recommend to the central government for the formulating suitable schemes for different sections of unorganized workers, gig workers, and who are the bread earners of a country. So, as said by John D. Rockefeller, I believe in the dignity of labor, whether with head or hand, that the world owes a man a living, but it owes man an opportunity to make a living. So, coming next to this is the data about the migrant crisis. So, like next, coming to these fundamental rights and those. So, can you like show that slide of fundamental rights and TPSP?
Yeah, it's on.
Thank you. In our glorious fight for civil rights, we must guard against being fooled by false slogans such as right to work. It is a law to rob us of our civil rights and jobs. Its purpose is to destroy labor unions and freedom of collective bargaining. our weapon is our vote, as said by Martin Luther King. So, as we can see here, that the fundamental rights and DPSP guaranteed to the laborers have been violated, the fundamental rights for Article 14, Article 15, Article 16, and many more were guaranteed to the laborers. And some of the DPSP's directive principles of state policy were guaranteed to protect the rights of the laborers. Uh, as we can see, they have been violated from the time immemorial. Now, talking about the ILO, International Labour Organization. Migrant, migrant workers contribute to growth and development in their countries of destination. The ILO works to forge the policies to optimize and benefits of labor migration for all those involved. The ILO Constitution declares that all human beings, irrespective of race, creed, or sex, have right to pursue both their material celebrity and their spiritual development in condition of liberation and dignity. ILO convention to which India is signatory expressed its disagreement with the amendments in labor laws done by the Indian states and advised to hold tripartite talks between labor unions, employers, and government before applying the amended rules. Exposing its laborers to do 12 hours of rigorous work should not be the norm in country that claim itself to be socialist, welfare, state, or labor friendly. ILO mandates and the failure. Workplace safety should be declared as a fundamental right and be comprehensively covered by the forthcoming OSHWC. India has, however, opted out from ratifying the provisions under Conventions 87 and 98. Convention 87 speaks of the right of the employees to organize and protest by means of nomination of this member from amongst themselves and represent their plights before the administration. While the administration cannot interfere with the functioning of such bodies, both these conventions aim to make unions a sovereign body that shall have power to protest and demand and even move to seek employment with bodies under International Labour Organization and accept financial support from elsewhere. There is also ILO Convention number 102, Social Security Minimum Standards of 1952, that renders social security coverage to all workers. In India, till now, only the life and disability cover, old age benefits, and maternity benefits have been provided under the Unorganized Workers Social Security Act 2008. The implementation has failed to translate from paper and is far from achieving the goal for these workers and has been seen during the COVID-19 pandemic. So now I want my friend to explain the statistical data on the labor rights.
So, from the Indian Journal of Labor Economics, I have got a data which has been sourced by Bhagat and Keshari 2013, which shows that the temporary seasonal migration rates by area and quintile levels, the lowest, as we can see, from the rural to the urban is 44.8, and the lower strata from 32.1, the medium being 23.8, higher being 17.3. The highest being 11.4 and a total of 26.4. While we can see that in the internal migration and gendered patterns in India, there has been a steady rise, 1971 to 2011. You can see the steady rise. This is the red is for the male from 19 to 22.6, and the female, it has also increased from 43.1 to 53.2. The blue being the total, the median of the both. Okay. So if we are looking at the welfare, the social welfare schemes, we can see that no bank account 19%. Sorry, I'm sorry. 1 second. No Aadhaar card 28%, unaware 36%, insufficient documents excluding Aadhaar cards 63%, migration 83%. So these are these are of the total number of people who have been surveyed in the process. And also, if you can see, be it in human development index or be it in the the social schemes that have been guaranteed to people all over the Asia Pacific, as well as the other countries that have been seen in the process, India stands at the lowest. It's the percentage of population in Asia and Pacific covered by at least one social protection benefits. And you can see India at the lowest. It's even lower than Bangladesh, Sri Lanka, Vietnam, and the other countries that you can see, Australia being at the highest of this particular survey. So scholars like Drez and Khera have argued that over 100 million people will be excluded from the coverage of PDS due to the dependence on the 2011 census for calculating the state-wise coverage of National Food Security Act. The biggest gap will be felt in the state of Uttar Pradesh and Bihar, where approximately 28 million and 18 million people, respectively, will be left out from the provisions under the National Food Security Act. You can see the data here, as you can see. Uttar Pradesh and Bihar being at the top of the grid. And the source is the Hindu. Okay, so we will now be wrapping up, and Rakshita will be talking about the solutions, the role of the judiciary, and will be concluding.
We must now wind it up,
Sure, sir. So let's be talking about role of judiciary. The Supreme Court fails to take the cognizance of the crisis. Alak Aloknath Srivastava, an expert in labor law of the Indian Law Institute, filed a PL petition which has been answered very negatively. The authorities were unconcerned and were ignorant. Being the custodian of the fundamental rights, it did not behave in such a manner. The court did not take account of the millions of the migrant laborers who were stranded on the streets across the country. However, the high courts were more concerned and responded actively to the plight of the laborers, as mentioned here. So let's be talking about the solution to the crisis. Dealing with the economic crisis, to overcome such difficult situation, government must loosen its fiscal restraint to stabilize economy, recover and grow. In the document released early in the pandemic, the Ministry of Health and Family Welfare pointed out that migrants need to be treated with dignity and respect, and in more practical terms, need to remain well informed about all sources of assistance available to them from appropriate governments. Instead of working in a positive direction, government was bringing out ordinances to humiliate laborers more. Working hours were being extended from 8 hours to 12 hours on the same wages and no compensation, with an excuse to bring economy in stabilized condition. Though was withdrawn later, instead government can support by providing wage subsidies directly to workers through digital payments. Also, it will help businesses to retain workers at the time of the stressed cash flow. Though there are many other aspects to the solutions to crisis, but the situation was vulnerable and critical too. Maybe the pandemic was so sudden that no one was prepared, but then necessary steps should be taken to protect the fundamental rights of the laborers. As said by Sir about the industrial harmonization that really protect the rights of the laborers. So the conclusion, injustice, any threat to justice everywhere, as said by Martin Luther King. The epidemic has come with broadly intense uncertainty. It is difficult to estimate how long and to what extent will the impact of this pandemic be on the lives of people and economy of the taking into account the current situation, which is more hazardous than it was the first wave of coronavirus. The situation is uncertain, and lockdown will again bring distress in the lives of the laborers. They will again lack resources, and prediction can be done that we are going to suffer a lot again, being the lowest class of the society, distress and labor. Therefore, this time, government must prepare beforehand to protect their lives, and there must be increase in the development of facilities which can be available to them to sum up. So yes, the government again will also face the dire situation and must adapt to the already existing labor laws instead of suspending them. They must not be misused to overcome the economic crisis.
That's right, that is it. Thank you. Thank you. Thank you. Well, I think we have been told with the sufficient data that during this crisis, both legislature, executive, as well as the judiciary let India and labor of India down. But I think one good feature was that the high courts in their respective spheres did a commendable job, which I think to a greater extent was responsible for getting things in order in many states. I hope and trust that Supreme Court has realized that it cannot sit back. It has to bounce back, and it has to come back to the position which it earlier had played. Was it should be seen as the last resort of the bewildered and marginalized people. And workers have all along been the marginalized lot, especially in the unorganized sector. And you must all know that we have only 8% of the workers in the organized sector. 92% of the workers are in the unorganized sector. Therefore, it constitutes the vast majority of the population of this country. And unless the state has an empathetic attitude and the functionaries of the state have that empathetic attitude, I think much remains to be done in this area. But I am very happy to note today that all the young people who have made their presentations are unanimous in their approach that fundamental rights, basic rights are not compromisable. They cannot be compromised. And the rights of the workers, which they have earned through their struggle over the centuries, cannot be taken away from them. And any attempt on the part of the state or any part of any functionary of the state will be resisted, and people will not tolerate that kind of an injustice, because our preamble to the Constitution starts with socio-economic political justice. We may have earned the political justice with right to vote to everybody, but we still are far away from getting what we call as social and economic justice. And that is the role that the young populace, students, lawyers, judges have to play in ensuring that this state is not reduced back to the Banyan state. It is a state which is a mighty state, but it must be a state committed to the socio-economic justice of the people of this country. Thank you very much. Thank you for your presentation. Who is the next?
Yeah, thank you, Mr. Chandril Chattopadhyay and Ms. Rakshita Bansal. So the next speaker for the session is Ms. Tanya Jaiswal, and she's a student at Jamia Millia Islamia, and she'll be presenting on pandemic time, constitution and labor rights.
Yes.
Ma'am, you may please present.
Thank you, ma'am. I need a second to present my screen.
My only one advice to the participants is that don't read your PPT. Make presentation, not reading what is written on the PPT that we can also read. So you have to make your short, crisp points that you want to make, because we are running short of time. There is another session that has to take place after some time. So therefore, I think it's very important to be, small is always beautiful. So therefore, if you make your presentation in crisp comments, that will be appreciated.
I hope it is visible to all.
Yes, it is.
So, good morning, everyone. This is Tanya Jaiswal. I am presenting my PPT on presentation on the pandemic time, constitution and labor rights. So, beginning with the introduction, during the period of pandemic, the sector the most effective is the manufacturing sector. Due to this, many laborers who were working have lost their job and many received pay cut. There is about 100 state laws and 40 central law that pass in the favor of the labor. In 2020, many states have suspended the labor law during this pandemic. So what is the vitality of the labor rights under Indian Constitution during this pandemic? I will first deal with the preventions which is given in our Indian Constitution for the labor rights. The main preventions, there is numerous labor preventions in our Indian Constitution for the labor right. That is Article 14, which is talking about the equality before law. Article 21 is the right to life and liberty is guaranteed under Article 21. Supreme Court has extensively considered this article and has constantly held that right to livelihood is inextricably linked to the right to life. Ultimate goal of Article 21 and 19(1)(g) to ensure that everybody has the means of subsistence. On Article 24, provide the prohibition of labor, child laborers in mind. We have Article 39, which ensure that state must adhere to such policy standard, which is like that all men have right to sufficient means of subsistence, ownership, and control of community material resources. The man and women are paid equally for equal work. We have Article 42, which is talking about the just and human working condition, maternity leave. Article 43, which is provided for wages, living wages for workers. Article 43A for the workers' participation in industry management. Apart this provisions in our Indian Constitution, we have the legislative ties. We have three lists, which is given in our Indian Constitution, that is union list, contract list, and state list. So we have like in union list, entry 13 that deal with the participation in international convention, 28 port quarantine related to the marine hospitals, 55 safety regulation for labor in mines and oil fields, 61 industrial dispute. In such a way, we have the continuously 94 inquiries survey status for the purpose of any matters given, provided, and encouragement of special studies and research. Entry 9 of the state list provide relief for disabled and unemployable labor. In contract list, entry 20, 21, 22, 23, 24, 25, given in our Indian Constitution, provided in the list setting. These all, if we're clubbing, this all talking about upholding the interests of the labor, upholding the rights of the labor. So what is the judicial stand? This is the base I'm providing you before coming to the suspension of labor right, which is done by numerous states. The Supreme Court held a series of decisions on this subject. The state has duty to protect the rights of workers in order to create a social and economic democracy in which all the workers enjoy socio-economic justice as guaranteed in the preamble, Article 14, 36, 15, 37, 21, and Directive Principle. Air India Statutory Corporation was a United Labour Union. Part 4 contained directives for all the common man to follow in order to achieve socio-economic justice. The poor, not man, the common man can secure and understand economic and social freedom only through right to work and right to adequate means of livelihood. That was said by the Justice Ramaswamy. We have case of PUDR was a Union of India 1982, which is same thing said in this judgment, that constitutional duty of the state to take the appropriate action for the purpose of interdicting such infringement and ensuring the observance of fundamental right. In the case of National Textile Workers Union versus Ramakrishna 1983, which is the Supreme Court upholding the workers have a special position in the socialist pattern of society. They are well traitors. BSK Sun versus Union of India 1981, which provide Article 37 of Constitution, state that directive principles are not less than fundamental in governance of the country. All men are equal, have equal opportunity in terms of economic, social, political justice. In this way, we have number of cases, which is talking about the importance of fundamental rights and BSK. In for the labor's rights. We have Chandra Bhavan Boarding versus State of Mysore, 1970. Of the year of 1970, the constitution mandate is to create a welfare state in which justice, social, economic, and political inform all institutions of our national life. Ranveer Singh was the of India in 1982, which, while the principle of fair pay for equal work is not specifically proclaimed a fundamental right our constitution, it is unconstitutionally a constitutional aim under Article 14, 1639C. So in FAIC and versus of India 1998, fair pay must depend on the quality of job performed. So most recent judgment in context of labor right, that is Gujarat Mazdoor Sabha versus State of Gujarat. Here, the bench led by D.Y. Chandrachud said that state could not have issued a blanket notification that exempted all the factories from complying with the human working condition and adequate compensation for overtime. As a response to the pandemic that did not result in an internal disturbance of nature that posed a grave emergency, whereby the security of state is threatened, so as to constitute public emergency under Section 5 Factory Act. Supreme Court emphatically stated, financial losses cannot be offset on the very shoulders of the laboring workers. Squash Gujarat notification permitting factories to extend the working hours. So these bases ensure that we have prevention for laborers, that state cannot breach it. But what is happening in this extreme situation during this pandemic, the state have relaxed the labor law. First state we have that is Uttar Pradesh, which approved the temporary assumption of certain labor law, and these suspension various act, few major ones are Contract Labor Act 1970, Industrial Employment Act 1947, Industrial Dispute Act 1947, Motor Transport Workers Act 1961, Trade Union Act 1926. No worker should be paid less than the minimum wages rate. The wages of workers should be within the precise time frame. We have Madhya Pradesh on since March 2020, Madhya Pradesh has passed the Labour Amendment Act. It includes various preventions for new factories. Certain prevention of industrial dispute Act 1947 would not apply. It's increased the work time. It's allowed the government allowed the overtime of 72 hours, and period of working shift has increased from 8 hours to 112 hours. There's a no inspection of firms having less than 50 workers. Rajasthan state government attract investment. They have increased the daily working hours from 8 to 12 hours, increased the retrenchment of layoff to 300 from 100. Punjab, Uttar Pradesh and Haryana have done the same thing just to lure the investor. They amended Factory Act and increased the minimum hours of working from 12 hours every day and 72 week from 8 hours to 48 hours respectively. So this, we have talking about the constitutional preventions. We see that how the state violated the basic fundamental right of the workers. There's there's a no timely wages provided since the quota of wages is suspended. There's a no legal commitment for the production line to give the convenient wages to their workers. Subsequently, law basically promoted abolition of minimum wages for workers in these foundation. Market economy. There is a marked inequality between the capital and laborers, more so in the country like India with pre-existing inequalities in society. Inequality results in lower bargaining power for the labor class and enable the factory owners to make the rules for the labor. Here, this form the private government, whereas the unilateral term setting in the workplace. Exploitation of workers, it's run contrary to the natural order of things of transformative change, which is need to great importance with the end goal to work back better and legitimize the administration mantra of Sabka Vikas, Sabka Saath, Sabka Vikas. Increase working hours, which is stretched out to 12 hours rather than 8. week after week, organization has launched 72 hours. In the modern trade sector, expansion in working hours is viewed as a chance to deliver all more, even with the deficiency of labor. Health of workers. These new laws additionally influence the labor and entitlement to welfare, relations, safe working conditions that fall inside the ambit of privilege to life under Article 21. Two-shift. The government should encourage the factory to follow the principle of two-shift, where it would be hire more employees and strengthen the growth of economy, increase the production. Development infrastructure is necessary that we have efficient development of infrastructure. Without the development of proper infrastructure, there is very limited chance of receiving a foreign investment. I believe that these steps which is taken by the state government in relaxing labor law under cover of COVID-19 pandemic are grossly unconstitutional, lead to a situation where economic power exercised by capital will be left unchecked. This would be lead to increase in hours of work, removal of minimum wages, and reduction of wages. Now, I would like to come to a conclusion that there is a need for serious debate on the future of labor right guided by B.R. Ambedkar inside constitutional guarantee against forced labor and understanding of force and freedom that takes into account difference in power. Passing of this ordinance by the various states is a significant step in generating foreign investment, but this should not be the end of efforts, should not be taken by the central government to make India a favorable investment destination for foreign investors. It is equally essential for generating economic growth. Basic human rights of labor are not compromised. There should be effort in creating a balance between both. Thank you.
Well, thank you very much. She has referred to some very important judgments. I think one of the important judgments she referred to was assured workers, where the Supreme Court raised the labor rights to the fundamental rights. And this is a beautiful judgment which all of you should study. They said denial of minimum wages amounts to begar, which is prohibited by Article 23 of the Constitution. Employment of labor, child labor, is violative of the fundamental rights of the labor, and therefore this is prohibited by the Constitution. Denial of basic rights to the workers by the state instrumentalities, those were Delhi Development Authority, Municipal Corporation of Delhi, and engagement of contract labor, which was not a genuine contract labor, is something violative of the dignity of the labor. She referred to another judgment, which is a very beautiful judgment, where Justice Bhagwati, heading a constitution bench, dealt with the subject of right of the workers to be heard in a winding of proceedings. There was no provision in the earlier Companies Act which gave right to the workers to be party to the winding of proceeding, because the Company Act itself is a very self-contained code. But the Supreme Court said, since the right of the workers to livelihood is involved, and you cannot take away the right of the livelihood of the people without giving them ad alterum paratum. You have to give reasonable right of being heard after Maneka Gandhi's case. All these judgments were watershed in development of the right jurisprudence in the country, especially labor right jurisprudence country. But these rights have slowly, gradually suffered demolition at the hands of the Supreme Court itself. And if the Supreme Court does not bounce back, does not understand the plight of the workers, which they are facing in the COVID-1 and COVID-2 situation, I'm sure the Supreme Court is losing its legitimacy. People used to have a lot of respect for this institution. And for that, the judges of that court worked very hard, especially after they gave a disaster judgment in ADM Jabalpur, where the majority of the judges undermined the importance of the fundamental rights. But then later on, through the public interest litigation, jurisprudence, they built up this public law where they opened the doors to the common man through their letters, through public interest, public spirited people, and developed a very great jurisprudence which is relating to the labor rights and rights of the common man. Therefore, the arguments that she was referring to it is something, we cannot allow fundamental rights of the workers to be dealt with the way they are being dealt with, because they are non-negotiable. The rights of the workers, which have evolved over the period of time through the efforts of the ILO, through the efforts of the constitution makers, and the efforts of the Supreme Court in the best period of the Supreme Court. When you read the 80s, Supreme Court of 80s up to 90s, you find that Supreme Court has done a remarkable work which has strengthened the labor jurisprudence of this country, and that cannot be allowed to be diluted and should not be allowed to be diluted. I'm very happy that the presentations are at least having a common chord, and that common chord is state beware, courts beware. You cannot do away with the rights of the workers. You can't do away with the rights of the workers. Your economic growth can be better only when you have a contented labor force, when you look after their needs, aspirations, and requirements, and keep them happy. You will have a very happy state of economy in this country. Who is the next speaker now? Last?
Yes, sir. The last speaker is Ms. Kohelika Nag, and she's a student at KIIT School of Law, and she'll be presenting on COVID-19 on the rights of laborers. Ma'am, are you here?
Yes, I'm here.
Yes.
Good morning, Chair, and all my fellow mates. I will be presenting
Slightly
on the
louder.
topic.
Can you just introduce yourself, because her voice was not
introduce her.
audible. So please tell us something about yourself.
So I'm from Kids School of Law, Bhubaneswar, and I'll be presenting on the topic COVID-19 on the rights of the laborers. I will be as the last speaker, I will be wrapping the entire thing in a nutshell. So first, if we focus on the word labor, it means someone who is employed in a particular sector, in a particular industrial sector. So does labor law, which means the laws relating to labor and employment, and it comes under the ambit of industrial law. It deals with various matters like working condition, employment, remuneration, industrial relation, and trade unions. And it also ensures social security and disability insurance. Now, I will be stating about who is responsible for providing safeguards to the laborers. The Ministry of Labor and Employment are responsible for providing the safeguards to the interest of the laborers who represent the poor, deprived, and unprivileged sections of the society. They make the healthy working atmosphere for the laborers, which further leads to higher production and productivity and development and coordination of the work ability coaching and employment services. Now we will focus on how this pandemic era has changed the face of the laborers. Before the pandemic era, that is the pre-pandemic era, the labor law was all about physical labor in industry. And after this pandemic came, the laborers had to suffer loss of meager income, due to which they have to undergo starvation, and due to these two factors, they are living an undignified life. With the COVID-19 as an excuse, the state is reducing the security which was available to the worker by eliminating or diluting various laws so as to favor businesses. Now, we will look upon what was India's decision. India's decision was to suspend the labor rights. As India was unable to cope with the pandemic situation due to its adverse living condition of the majority of the population, so the labor laws in India are being diluted, which will ensure a worsening of the living condition of the laborers. This will further ensure that the next pandemic comes in due course, the country will flounder. Now, this tragedy in India is today headed towards a societal breakdown for short-term gains of some. While considering the suspension of labor rights on May 8, 2020, the UP government promulgated the ordinance which suspended a majority of the key labor laws and rules thereunder in the state for all factories and establishments engaged in manufacturing process for a period of 3 years. In India, several states like Maharashtra, Madhya Pradesh, Haryana, Uttarakhand, Himachal Pradesh, Uttar Pradesh, and Gujarat have announced the suspension of labor laws. Then, the suspension of various legislation relating to labor laws like Equal Remuneration Act, the Minimum Wages Act, Contract Labor Act, and the Minimum Wages Act raised fundamental rights challenges, which was held in TUDR versus Union of India and in Bandhwa Mukti Morcha versus Union of India. Now, the implications of the suspension is that this move, which was made by the government, the aim was to revive and boost up the government's.
Yeah, you were not audible. Yes, now I can hear you. Ma'am, we can't hear you.
Yeah, we can't hear you.
I think there's some network issue.
Some communication problem.
Yes, maybe.
Just give her a call. She is not audible.
Hello? Yeah, she's not audible.
Yes, sir. She's left the meeting. I think there's some network issue. Yeah, she's back. Miss Kohelika? Ma'am, are you? Hello? Ma'am?
Yes.
Yes. Let's continue.
Yes. So lastly, I would like to say that these both the options will involve a radical transition from the status quo, and the socio-economic cost of such transition will not be insignificant. The policy makers should decide whether the political virtue signaling is worth the spectre of loss of life, livelihood, and the property that looms ominously on the horizon, and the precariat cannot be made to bear the costs of the lockdown. Thank you.
Thank you. Well, that brings us to the end of the presentations in this session. All the presentations have been very good, and there's a common thread passing through all the presentations, and that's very on a happy note that rights of the labor need to be honored, need to be respected, and need not to be, diluted. They have to live a life of dignity. They have to contribute to the health and wealth of the nation, but that they cannot do if they have a hungry stomach. They do not live in good conditions of life. So therefore, the dignity of the labor we must uphold. We must uphold the international conventions. We must uphold the constitutional values that permeate the provisions dealing with the labor rights. So therefore, Supreme Court must rise to the occasion and see that those laws which are inconsistent with the constitutional values or the basic structure are thrown to the winds, and right of the laborers are honored. But I think the workers also have to be very disciplined, and employers also, of course, are facing tough time because their investments are stuck, their earning is stuck. But I think we have to find some ways other than diluting the rights of the workers. Government has to evolve policies, making available various schemes to the employers, but we cannot do away with the rights of the workers. I think that is the common idea that I got from all the participants that participated today in the deliberations, and I'm happy to note that we are all one in this approach. And this is the way forward, which we must be able to communicate to the authorities who are the decision makers, policy makers. Thank you very much. I enjoyed every bit of it, every presentation that has been made by the young boys and girls, and I'm sure that this country has a very good future. Lawyers in making, judges in making, administrators in making are very compassionate. And I'm sure whenever they have a brush with the law and implementation, deciding, arguing, they will keep the rights of the workers in their hearts, and they will like to give life and what we call as blood and flesh to the bony skeleton of the labor laws in this country, and evolve a good jurisprudence of the rights of the workers, rights of the employers, rights of the society, because every industrial dispute is a multi-party dispute. It's not dispute between employer and employee. It is a dispute which involves the state, involves the uh, uh, finances of the state, involves the profits, involves the wages and good conditions of service, and services and goods that must be made available to the people with reasonable costs and without interruption. Thank you very much.
Professor Kaul, accept our heartfelt thanks, despite the fact that you have just recovered from the COVID and your academic enthusiasm is always, inspiring for the budding students. In fact, we used to call Professor B.T. Kaul the academic dinosaur of legal fraternity. He combined in himself a legal luminary, having a large research experience. He was one of the best teachers in the law faculty. And, he is such a magnanimous person who has fought several cases for the laborers free of cost. And now he is the senior advocate. And that is one of the few people who have got this, opportunity to serve the country. And, being a researcher, being a teacher, being a practitioner of law, I think he amalgamated himself several things. He has been a constant, resource person for the judicial academies. He has motivated several judges to, be liberal in their approach while dealing with the cases related to poor people. I hope Professor Kaul will be a frequent visitor for our various webinars, series of webinars, which we generally keep on doing on special days, just like we did one on Women's Day, one on Consumer Day, and now one on Labor Day. So next celebration would be also there on International Day. I don't know right now. We have to plan about that. But Professor Kaul has been a source of not only inspiration for me, He has inspired several new budding scholars. So thank you, sir. Thank you. So
Thank you
kind
very
of
much.
you. Thank you for
Thanks a
being
lot.
us.
Thank you. Thank you very much. God bless you all.
Thank you so
Thank
much.
you.
Thank you, sir.
I think with this we come to the end of the first session. And sir, Dr. Vipin Malhotra, sir, shall we start with the second session?
Yes, please that.
Yes. So the theme for the second session is a holistic approach to labor rights international scenario, which will be chaired by Dr. Vipin Malhotra, sir. So for the first speaker for the session is Ms. Purnima Goyal, and she's a student at Lloyd Law College, and she'll be presenting on labor rights amidst global crisis, challenges and solutions. Ma'am, please, you may start with the presentation.
Yes. Hello, good morning to everyone present here. Am I audible to everyone?
Yes, ma'am, you are, but your voice is cracking. If you could please.
Yes, you are very much audible. And
Is it clear now?
Yes, it is very much clear. And one thing I would like to, request the participants that please don't read your presentations. Please speak extempore, speak from your heart. Whatever research you have to present before the audience has to be in your own language. So that is a better way of presenting. Otherwise, if you will read, every paper requires 25 minutes. But if you summarize the paper in your own words, I think you can finish within 10 to 15 minutes. So that would be there. So
yes.
Having said that, the only person who has to speak less is the chair. So I restrict myself here. And yes, over to Purnima.
Yes. So yes, here's my topic, labor rights amidst COVID-19 pandemic. Labor is the precious, valuable, and useful asset of every organization whose rights should be secured and preserved. Labor rights and worker rights are human as well as legal rights, which depicts the interrelationship between the employer and the employee. In a general sense, these labor rights impact the working conditions of employment. No one is allowed to exploit the worker just to get out more successful or profitable business. Thus, we have a moral and legal responsibility to preserve them. Labor laws are implemented to ensure protection of their rights. Labor laws are the ones that synchronize the attitude of the employers towards the treatment of the labor force at the place of work. The law also deals with matter of employment, industrial relation, trade unions, work conditions, wages, and etc. In a broad sense, the term includes the social security and health security. Under the Constitution of India, labor falls within the concurrent list, which means both central and state government have given the power to make laws on the subject matter, which is labor. Uh, the Ministry of Labor and Employment works for the safety and security of the interest of the workers and the poor, deprived, and disadvantaged sections of the society. The ministry focuses on creating a healthy working environment to enhance production and productivity and to develop and unite ability, guidance, and employment. In compliance with privatization and liberalization, the ministry's motive is to promote welfare and provide laborers with security in both the sectors, the formal sector and the informal sector. Accordingly, the ministry had constituted a board named National Social Security Board, which suggests the formulation of social security policies and schemes relating to life and disability, old age protection, health benefits, economical assurances, maternity reliefs and benefits, etc. The ministry also aims at eradicating child labor throughout the country. Then the ILO, the International Labour Organization, which is an agency of United Nations whose degree is to strengthen social and economic justice by the way of situating international labor standards. The organization is truly admired for promoting justice and internationally recognized human and labor rights, following its founding mission that labor peace is essential to prosperity. The ILO helps in encouraging the formation of decent work and the economic and working conditions that give the working class or business holders a stake in long lasting peace, security, progress, and prosperity. In India, labor laws are continuously evolving and aims to sort out the long-term issues plus to reshape the changing necessities and requirements of labor market. For example, earlier the labor law includes only the most developing and important industries, and now afterwards the scope of labor law was elongated to include the other small undertakings, handicrafts, rural industries, agriculture, etc. Earlier, gig and platform workers were not embraced in any early labor legislation, which means someone who takes on hourly and part time jobs. And now they were incorporated under the 2019 Code on Social Security. That's how labor laws are evolving. Then the rights of a labor. The rights of a labor covers a broad dimension which provides them security against social disruption, economical loss, political disturbances, etc. So the first right available to a labor is freedom to work. The right to freedom of work portrays the right to be employed and which also implies the right not to be destitute of employment unreasonably. The laborers have given the right to be employed in any profession, occupation they wish to, unless given a fair reason as to why they cannot. Then, second, freedom to choose occupation along with the place of performance. Uh, this is elaborated under the section under the Article 19(1)(g) of the Indian Constitution, which is a fundamental right which grants upon the citizens the right to make use of any profession, carry on any occupation, trade, or business. But this is not an absolute right and limited with some reasonable restrictions. They can also choose the place of work as per their duties and responsibilities. Then, third, freedom to initiate autonomous employment business. This is somehow related to the second one. That is, every person is allowed to start up any business, occupation, and profession of his choice on his own. Then, fourth, right to earn a living. The right to earn a living is every citizen's right to fulfill all his basic needs and demands and of his family as well. Earning a living is a direct sort of survival. Then, right to free employment services. Each person has a right to get free employment services in which he gets fit for the purpose of higher production and productivity. Then, right to safe and healthy working conditions and environment. In respecting to the right to safe and healthy working conditions, the employer should take up all the essentials to reduce the number of risk of accidents, injury, and death, come up with vital protective equipments to ensure safety, provide measures to deal with emergencies, supply adequate sanitary facilities, including first aid arrangements, take remedial measures to prevent laborers from unsafe and unhealthy working activities at the place of work. Then, right to rest, leisure, and reasonable working hours. In the 19th century, there was a recognition that working excessive hours posed a danger to workers' health and to their families. Rest is as important as work for the overall growth of a person. Reasonable working hours, leisure time, and the time to take rest helps in self development. It is requisite for both the body and the mind. Right to be employed. Right to be employed is every labor right and should have given a chance to be employed in any field of work he desires. And it is the duty of the state to ensure full employment in our nation. Then, right to promotion. Right to be considered for promotion is the labor's fundamental right if he passes all the eligibility criteria to be suitable for promotion against any vacancy if available. Then, right not to be arbitrarily dismissed, which is unfair dismissal. Unfair dismissal is an act of employment termination made without good reason or contrary to the country's specific legislation. There are many situations where the employer fires the laborer who, without any reasonable ground or where the termination is irrational. Personal bias and grounds related to motherhood and pregnancy can be a cause of illegal removal of employment. Right to be secured against unemployment explains the duty of the state to manage continuous efforts to make sure full employment. It is the duty of the government to assure that no one died because of hunger, whose ultimate determinant would be unemployment. Right to protection against exploitation is enshrined under Article 23 and Article 24 of the Constitution of India. Article 23 prevents trafficking in human beings and forced labor. One cannot be forced to recruit in labor without the will of the person, even if the consideration is paid. Article 24 prohibits employment of children in factories and other hazardous industries or mines. Then right to be informed. The laborers have the right to information about what kind of work they would be involved into. They should have given the opportunity to take part in the decision-making process for the benefit of the business or regarding the business policies. They should have given the information about the particulars and details of the firm, company, for the better functioning and coordination. The right to get proper assistance and guidance. The employer must give the proper assistance and guidance to the labor so that they can make a good use of the machines and equipments, and which results in higher productivity. The guidance or instructions should be provided in a regional language so the laborers are able to understand it easily. Right to compensation. The compensation has to be given to the laborers in case of any injury caused to him at the workplace. Firstly, the employer has to keep a check on the activities of the worker and ensure that no one get harmed. And if they have to suffer, they are entitled to compensate by the employer itself. The Workmen's Compensation Act 1923 requires that compensation is paid if workers are injured in the course of employment for injuries or benefits to dependents. This act aims at providing financial assistance to the laborers in case of any accidental injury caused to him. Right to have access to technical and educational trainings. Technical and educational trainings shall be made generally available to the laborers, which helps them in creating a high standard of thoughts and higher standard of living. This not only helps laborers but their families as well. All laborers should have equal access to the facilities and trainings provided to them. The government has to conduct more policies and programs to train the laborers in their field of work. Right to be included in government policies and programs. All the laborers have given the moment to take participate in all the government policies. They should have given a fair chance to be indulged in all the workshops and seminars. Right to equality of treatment and non-discrimination. The principle of equal treatment is based on to ensure all employees have the right to receive the same treatment and not to be discriminated regardless of a worker's position, age, disability, sex, race, and religion. Discrimination based on these factors can create obstacles in the active coordination among the labor force. Right to health security and social security. Social security is a sound instrument to combat discrimination and an essential tool for reducing poverty and supporting social inclusion. It aims at providing income security and support at every stage of life with particular attention to the most marginalized section. According to the Occupational Safety, Health and Working Conditions Code 2019, every director or manager shall warrant that the workplace is free from any threat which cause or likely to cause injury, hurt, or disease to the employees. Then the last one, right to form associations and unions. This is elaborated under the Article 19(1)(c) of the Indian Constitution that all citizens have the freedom to form associations or unions for a lawful reason. This right certifies that every individual is at liberty to arrange or organize or create or take participate in any group or gathering, whether it be formal or informal. Freedom of association is a very important right of a worker to shield their interest for the target of negotiating salaries, policies, benefits, schemes, and other conditions of work. it considers as a fundamental right because it depicts the democratic nature of our government and its governance. Then, uh, how COVID 19 affected these workers. Now, as we all are aware about the fact that COVID 19 has attacked all of our lives in every possible sphere. India is a country where the workers or laborers dispense their services and earn a living out of it. COVID 19 has affected these labors to the worst. And not only India, even other nations have seen a downward graph in representing the labors in the industries and factories. Indian laborers have faced multiple hardships during this heavy period of time. Millions of laborers had to deal with the loss of income, shortage of food, and uncertainty about their future and families due to the shutdown of the industries and factories with the imposition of lockdown all over the country. The outbreak has dangerously hit the laborers, specifically those who are employed in the informal sector, which pretty much govern like 85% of the total laborers or workforce. In addition to the laborers, migrant laborers are also facing so many difficulties and challenges during this period. Migrant laborers are the unpretentious and unskilled workers who provide their services on a temporary and seasonal basis, moving from one place to another in search of work. The United Nations Convention on the Protection of the Rights of All Migrant Workers and Members of their Families define a migrant worker as a person who is engaged in a remunerated activity in a state of which he or she is not a citizen. According to the World Economic Forum, there are an estimated 139 million migrants in the country. It was stated that the migration for work is higher among the interstate migrants, which is 50% of male and 5% of female. Movement of female for work is recorded due to family reasons. The COVID 19 pandemic and the related policies of confinement, such as curfews and weekend detention, expresses our poor economic, social, and political policies. Now, steps taken by the central government and Ministry of Labor and Employment. To resolve the grievances of laborers, workers during lockdown, Ministry of Labor and Employment had set up control rooms all over the country. During lockdown, more than 15,000 complaints of the workers were resolved through these control rooms. And due to the intervention of central government and Ministry of Labor and Employment, more than 2 lakh workers were paid their due wages amounting to about rupees 295 crores. Per day wages under MG Narega have been raised from rupees 182 to rupees 202. The central government is also encouraging the rights of the workers by providing them with all the terms and policies. Now, several states in India has also issued various notifications and ordinances, including dispensation from compliance with certain labor laws to stimulate the growth of the economy amidst the ongoing pandemic. So, as we cannot share all the states, so we just discuss about some. So, the first is Rajasthan. The state of Rajasthan has promulgated a notification for increasing the maximum daily working hours from 9 hours to 12 hours, which implies maximum weekly working hours from 48 hours to 72 hours for a period of 3 months. Certain relaxation have also been granted to factories producing essential goods and grocery supplies so to turn down the requirements of manpower, and conditions were also laid down. Additional 4 hours per day shall be required to get an overtime pay. Gujarat. The state of Gujarat has issued a notification exempted all factories registered under Factories Act 1948 from several provisions, such as no adult worker is allowed to work in the factory for more than 12 hours, which is earlier than 9 hours. It also increased the maximum daily work hours from 9 hours to 12 hours, which implies increment in maximum weekly work hours from 48 hours to 72 hours for the period of 3 months. Wages shall be given in proportion of the existing wages, and no female worker is required to work between 7 p.m. to 6 a.m. in any factory. Madhya Pradesh. Likewise, the government of Madhya Pradesh also amended Madhya Pradesh Labour Laws Ordinance 2020. The ordinance elaborates the suspension of provisions of Industrial Dispute Act 1947. The exemption is pertinent for a period of 1,000 days, subject to the conditions applied. The ordinance also exempted the factories from the provisions of the Factories Act 1948 and Madhya Pradesh Factories Rules 1962 for the period of 3 months. Then Himachal Pradesh. Himachal Pradesh has announced to exempt all factories registered under the Factories Act 1948 from provisions relating to weekly, daily, spread hours and interval of rest until the period of 3 months starting from the announcement of the notification respecting certain conditions. Incrementing working hours for the adult workers from 9 hours to 12 hours. Overtime pay shall continually be applicable for earning overtime wages without any change in this respect. And female workers not allowed to work in any factory between the times of 7 p.m. to 6 a.m. Then Uttar Pradesh. The government of Uttar Pradesh has suspended nearly all labor laws and rules under the state for all factories and establishments engaged in the manufacturing process for a period of 3 years. The ordinance named as the Uttar Pradesh Temporary Exemption from Certain Labor Laws Ordinance 2020. It also increased the daily work hours for adults from 9 hours to 12 hours. Whereas exemptions are yet put through various conditions, which are as follows. No laborer shall be paid any less than minimum wage as prescribed by the UP government. The salary or wages to the worker shall only be given in their bank accounts. The provisions of the Factories Act 1948, the Building and Other Construction Workers Act 1996, the Workmen Compensation Act 1923, Abolition of Bonded Labor System Act 1976 shall remain applicable. The provisions of the various labor laws relating to the employment of women and children shall abide by the Constitution even in the pandemic times. Now, here's the conclusion. These renovation of these labor legislation have urged the factories to back up with their functions, but with various conditions applied to them. They must ensure the proper sanitization and social distancing rules and precautions for the safety and security of the laborers. They are subjected to their wages and salaries along with the compensation as well, according to the orders of the central and state government. Many of the labor rights are considered while putting up these renewed laws. The orders given by the government is highly criticized by the trade unions and other production companies who says that these laws are against the standards of labor legislation. But on the other side, these are necessary for the nation's economy, wealth, functioning, growth, and governance. If they didn't follow up these rules, the situation would get worse as they would not left with any other option and their life and safety will be at risk. All these notification and ordinances, including dispensation from compliance with certain labor rights, are announced just to stimulate the growth of the economy amidst the ongoing pandemic. Yes, sir.
Okay, Purnima, it is well summarized, and the kind of legal paraphernalia which is there to protect the rights of laborers is diluted as if it is the only hindrance in the economic growth of India, setting aside the other, reasons which are very much vivid and overt: red tapeism, corruption, higher taxes, inadequate infrastructure, unskilled workforce. So these things have not been taken into account as much, though Skill India, Skill Development Ministry was set up, and there is a stress on MSME also. But as you well said, that it is just one side of the picture, and you could well see how pitiable conditions the laborers are facing at the time of COVID. They had to travel by foot travel by cycles, travel by, trucks, travel by, mindlessly crowded trains during the COVID period, and several workers had lost their life. So this shows that how inhuman situation is existing as far as the laborers are concerned. It is not only about the organized laborers, unorganized laborers are also facing lots of hardship, which constitutes more than 80% of the workforce. And in this robotic age where there is hardly any scope for unskilled labor, the legal fraternity has to come forward along with the psychologist, along with the social scientist, to contemplate a world where it is governed by, you know, uh, artificial intelligence at the doorstep and robotic industrialization. A $1 trillion company is managed by less than 1,000 people, and it is matching the budget of India, and it is only managed by a few thousand people. It is a real, example of concentration of wealth, that this concentration of wealth would render the laborers forlorn. And, it is a targeted study, and I really congratulate you to conduct this research, and I wish that you should take forward this study further. So let us go to, I think, next presentation.
Yes, sir. Thank you, Ms. Purnima Goyal. Next speaker is Ms. Neelam, and she's a student at Army Institute of Law, Mohali, and she'll be presenting on labor rights amidst COVID-19, ramifications of suspension of labor laws. Ma'am, you may start.
Thank you, Ms. Zainab, for the introduction. I'm really
Please,
grateful.
I again, request the presenter not to exceed more than 15 minutes.
Yes, sir.
Right
Sure.
now it is 12:14, so try to finish it before 12:30. Okay? So please do that. So do adhere to the time limit.
Yes, sir. I'll now present my screen. Uh, is it visible?
Yes, ma'am, it is.
Thank you. So the topic of my research paper is labor rights amidst COVID-19, ramifications of suspension of labor laws. To begin with the introduction, COVID-19 pandemic has engulfed the entire world in public health and economic crisis. And under the lockdown, millions of people, especially the migrant workers and laborers, lost their means of livelihood. With an aim to incentivize the economic activities, state governments came up with sweeping changes in their labor laws. Labor laws fall under the concurrent list of the Constitution, and therefore both the Parliament and the state legislature can make laws regulating labor. Labor laws have always been considered as a stumbling block in encouragement of investment and expansion of industries. And in my opinion, the COVID-19 crisis now appears to being used as an excuse to drive through the unfinished reforms agenda of increasing working hours, lowering wages to the bare minimum, cutting social security benefits, allowing the use of contract labor for any type of job, loosening dismissal rules, curtailing trade union rights, and reducing labor inspection. So the objective of my study is to know whether suspension of labor laws is actually going to encourage the industries to invest in the states concerned, or these measures will result in the exploitation of labor without a matching improvement in investment. To begin with, the suspension of labor laws, on 8th May 2020, an ordinance named Uttar Pradesh Temporary Exemption from Labor Laws was promulgated by the Uttar Pradesh government. As a result of this, 35 out of 38 existing labor laws will remain suspended in the state for the next 3 years. This action was justified by stating that liberalization or exemption of most of the labor laws will help investments to flow into Uttar Pradesh, and thereby there would be economic revival and at the same time creation of jobs. So the only labor laws that remain functional in the state are the Workmen Compensation Act 1923, the Bonded Labor System Abolition Act 1976, and the Building and Other Construction Workers Act 1996, along with the Section 5 of the Payment of Wages Act. Beyond this, any laws related to the deployment of women and children will not be diluted under the ordinance, and the state of Madhya Pradesh, Rajasthan, Gujarat, Himachal Pradesh, Orissa, Punjab, etc. walked in the same path and introduced similar provisions regarding labor laws, though in smaller scope. So, issues pertaining to the suspension of labor laws. The sudden suspension of labor laws puts the entire labor class under the threat and risks of bondage labor, lower wages to women, lack of job security, and increased risks to the health and security of all workers. With the dilution of the Minimum Wages Act 1948, wages received by the workers would not be regulated. In the Bandhua Mukti Morcha judgment of 1984, the Supreme Court affirmed that payment below the minimum wage would amount to a situation of bondage. In the case of Sanjit Roy versus the state of Rajasthan, it was also held by the Supreme Court that if the worker is not paid the minimum wage, the work then constitutes as forced labor in complete violation of the Indian Constitution. The Factories Act 1948 provides for a legal framework for workers' fundamental rights such as fair working hours, leave time, and overpay. Suspension of this act poses a great risk to the safety of the worker. A situation like this would be a breach of Article 21 of the Indian Constitution, which guarantees not only mere existence but also the right to dignity and all other aspects of a person's life. The Labour Departments of Gujarat, Madhya Pradesh, and Himachal Pradesh released notices extending factory workers' working hours to a maximum of 12 hours per day and 72 hours per week, citing a public emergency. What is important to note here is that for the purposes of Factories Act, a public emergency is described as a grave emergency in which the security of India or any part of its territory is threatened, whether by invasion, external aggression, or internal disturbance. COVID-19 may be the most destructive pandemic in human history, but it still does not count as a national emergency under the new version of the Factories Act 1948. The Industrial Disputes Act 1947 protects employees from being fired for reasons that aren't fair, such as their membership in a union or involvement in a protest for better remuneration or working conditions. With the dilution of this law, there will be no rules governing the hiring and firing of employees. Ironically, despite the Supreme Court of India acknowledging the right to access to justice as a constitutional right in the case of Anita Kushwaha versus Pushpap Sadan, the grievance redressal procedure for them, as given in the Industrial Disputes Act, is also unavailable due to the suspension of the laws. The Uttar Pradesh Ordinance also seeks to suspend the Trade Unions Act 1926, which empowers workers to form trade unions for the regulation of work-related matters between employers and employees. The suspension of the Act is in violation of Article 19(1)(c) of the Indian Constitution, which guarantees the right to form associations and unions and includes the right to form trade unions, as held in the case of Raja Kulkarni versus State of Bombay. Now, I'll come to the violations of the ILO Convention. So, India is signatory to the International Labour Organization Convention, and the aim of this convention is to improve economic working conditions so that all employees, employers, and governments have a stake in long-term stability, prosperity, and development. India has also ratified the Tripartite Consultations International Labour Standards Convention 1976, which codifies ILO's spirit of tripartite consultation between the country, the employer, and the workers. But these ordinances have been introduced unilaterally and inspections have been done away. These ordinances seem to be in direct breach of the International Labour Organization conventions, which are internationally recognized benchmark for what domestic labour law should aspire to be. Now I'll come to the main point, which is, will suspension of labor laws boost investment? So there is very limited evidence that introducing flexibility or suspending labor laws would boost jobs or attract more investment. It is not the labor laws' rigidity that constrains investment inflows. There are other economic aspects related to the ease of doing business, like extensive infrastructure, high availability of muscle power, political and economic stability, hassle-free and investor-free environment, etc., which increase investment. In the World Bank Enterprise Survey, which polled 9,281 businesses across India, it was found that less than 5% of the businesses cited labor regulation as a major stumbling block to their operations. And after the survey, this number has scarcely changed. So, skilled muscle power, extensive infrastructure, and various other aspects mentioned above are responsible for investment or lack of investment in the state. The Uttar Pradesh government must rather look at revamping skill development program and also restructure the educational institutions to make available a large amount of surplus power. So this survey over here shows the primary issues faced by firms for investment. So for Indian businesses, electricity, corruption, and tax rates are more significant constraints than labor regulations in increasing investment. This chart over here by the World Bank Enterprise Surveys shows the share of firms listing labor regulation as a primary issue. And here, as it can be clearly seen, that for Indian businesses, labor laws are seldom a major stumbling block. So the very fact that millions of workers migrate from the state of Uttar Pradesh points that there is something wrong in the way the economic policies and the labor laws are being envisaged and administered. Investments will flow only when the employers are assured that they could have a dialogue with recognized trade unions and labor standards are good, and as a result, the productivity and economic efficiency will increase, and thereby both the employers and the country could reap the benefits of it. But in my opinion, in the name of labor law reforms and granting labor flexibility to employers, the state governments are making an attempt to weaken the labor standards. So, overall, a stronger, although a little more complex solution would be to finish the process of developing a comprehensive, integrated legal system for labor that is light on compliance and administrative standards while ensuring that workers' rights are protected. This will help to attract the right kind of investment while also avoiding potential worker abuse. Finally, I'll come to the steps to be taken ahead. So, workers are and will continue to be increasingly important in the workplace, necessitating the attention and cooperation of governments and other related stakeholders. There's a need to press for greater awareness of the advantages that migrant workers bring to the states and the country, as well as for policymakers to take a more pro migrant stance. This pandemic is an excellent opportunity for the government to create new types of economic structures and institutions in the country, especially in the rural areas. The lack of fair treatment of employees has been a glaring flaw in this dispersed production model so far. Steps must be taken to increase migrant workers' engagement in unions and organizations to ensure that their voices are heard in social dialogue processes. With rapid technological advancements transforming the landscape of jobs across all sectors, India's migrant workers must be equipped not only to remain relevant, but also to benefit from these changes. A skill mapping and skill growth roadmap for migrant workers must be developed by the Ministry of Skill Development and Entrepreneurship. With this, I rest my case. Thank you for being a patient audience.
Yes, it's really wonderful. And the kind of issues you have raised about the rights of laborers require special attention. As you know, I have stressed on the fact that we require more social security, and we have to stress on other factors also, wherein we have to consider that by industrialization has not been able to take a jump, despite the fact that India is a country with rich resources, which not only include the natural resources, which includes human resources as well. And I don't understand why under the Factory Act, there is more, a need for modification from increasing the hours from 9 to 12, because we do not have any dearth of labor. We have, in fact, more surplus labor, and we have overemployment also in certain sectors. So these things have to be kept into mind. And while suspending the labor laws, what state wants to convey? That is a big question mark. That as if, these labor laws are the hindrance, So do you want to create a lawless society? Do you want to be anarchist? Do you want to be, following the extreme liberal path, which is now non-existent? And in fact, if you see the global position, no one is willing to migrate to the socialist countries. There is hardly any migration to Soviet Union. There is hardly any migration to China. There is hardly any migration to other, communist countries, which are having a big paraphernalia of labor laws. And, most of the people are, migrating towards Scandinavian countries, Western countries, USA, Canada, because they have a strong social security system. So, where you have now robotic production, and, in India, only less than 2% people are skilled workers. And you must have a strong social security, and it is a part of now labor code bill of the four codes which are being enacted by the parliament, and still rules and regulations have to be improved. So the concern for social security must be now at the top right now, and the rights of laborers can only be protected by that, and in fact increasing the work time will not help at all, because we have already surplus labor. And as far as Manrega is concerned, I think it is itself violating the Minimum Wages Act. Just providing 180 rupees per day or 200 rupees per day. It is not nowhere, I think it is part and parcel of any Minimum Wage Act. So I don't know what paradox we are, addressing to, and state is itself violating its own laws, then whom to contact, because permanent posts are not being filled, and employment is a far-fetched reality in the government sector, in the public undertakings are being closed, and people are more happy to work with multinationals than with, domestic players. Why? Because, they get more facilities there. So that is one of the reasons that, we have to rethink the whole dialogue, that where we stand in enacting the labor laws. Should we loosen the labor laws? Should we make it more flexible? Or we should address to some other issues more coherently than these labor laws to make this country a developed country. Anyway, we move towards the next presenter. Yes, Zainab.
Thank you, Ms. Neelam. So the next presenter is Ms. Anjali Kumari, and she's a student at Bharatiya Vidyapeeth Deemed to be University, which is the New Law College of Pune. And she'll be presenting on impact of COVID-19 on the rights of laborers and workers in India. Ma'am, are you here?
Her name is Anjali.
Yes, sir.
Okay.
Anjali Kumari. Miss Anjali Kumari, are you here? Yes, she's here.
Yes, I'm here.
Okay, ma'am, you may start.
Yeah. I hope my PPT is visible.
Yes, ma'am, it is.
Greetings, everyone. I am Anjali Kumari of Bharati Vidyapeeth University, New Law College, Pune. I'm here to present my paper on impact of COVID-19 on the rights of laborers and workers in India. To begin with introduction, the ongoing global pandemic health the ongoing global health pandemic called COVID-19 has already caused death of people all over the world in the last few months. The scale and the magnitude of the pandemic are so huge that it is being compared to the 1918 global pandemic called Spanish flu. The COVID-19 pandemic has brought the entire world to its knees, causing widespread destruction, panic, and economic misery. Several countries have been forced to take extreme steps to stop the spread of the disease. Thus, numerous countries have announced lockdowns of different degrees to keep people at home by enforcing strict physical distancing to break the transmission of the infection. This endeavor of keeping people at home has resulted in enormous social and economic interruptions as people are unable to consume various goods and services, which in turn have crippled economies and squeezed the income, profits, and investments of several businesses. One of the adverse health fallouts of the COVID-19 pandemic has been that it has put enormous burden on the health infrastructure of countries. In several countries, COVID-19 patients have overwhelmed hospitals. Moving to the next slide. Concerned about the availability of adequate health services, some countries, as emergency responses, have nationalized hospitals. Countries like United States have taken emergency steps to boost the production of ventilators that may be needed to treat patients affected by COVID-19. Under the Production Act, COVID-19 has also affected India, causing thousands of human deaths and infections. In order to stop the spread of disease, the Indian government has also taken a number of regulatory steps. The most important step in this regard was to announce a nationwide lockdown on 24th March 2020 under the Disaster Management Act, which was further extended. According to a study done by Oxford University, India's lockdown is the severest in the world. All modes of connectivity by road, air, and rail have been snapped, bearing some exigencies. The nationwide lockdown has vastly dislocated supply chains and brought several economic activities to a halt, and thus affected numerous domestic and foreign investments. The labor market have also been dislodged, and large number of people are not being able to report to their work due to lockdown. Due to lack of livelihood opportunities and several economic hardships, blue collar workers, of which a large number are migrant laborers, have fled their workplace. Now, talking about how is labor regulated in India, labor fall under the concurrent list of the Constitution. Therefore, both Parliament and state legislature can make laws regulating labors. Currently, there are 100 state laws and 40 central laws regulating various aspects of labor, such as resolution of industrial disputes, working conditions, social security, and wages, to improve ease of compliance and ensure uniformity. In central level labor laws, the central government is in process of codifying various labor laws under four codes. First is industrial relations, second occupational safety, health and working conditions, third is wages, fourth is social security. Now, labor reforms in the age of COVID-19. Amid the coronavirus-induced lockdown, an increasing number of states that include Uttar Pradesh, Madhya Pradesh, Rajasthan, Gujarat have pushed through changes to their labor laws by way of amendments, ordinance, or executive orders. They aim to provide some sort of blanket exemption to employers from labor laws. The government of Madhya Pradesh also promulgated Madhya Pradesh labor laws, that is amendment, Ordinance 2020. This ordinance provides for suspension of Industrial Dispute Act, and laws that were amended are as follows: Madhya Pradesh Industrial Act, Standing Orders Act 1961. By promulgating, the government of Uttar Pradesh suspended all labor laws. The Uttar Pradesh temporary exemption from certain laws, Ordinance 2020, Section 3 of the ordinance lays down the labor laws, section of labor laws and other rules that will be remaining in force in this period of 3 years. According to this, the law that will continue to be enforceable in the state are as follows: the Building and the Other Construction Workers Act 1996, the Workmen Compensation Act 1923, the Bonded Labor System Abolition Act 1976, Section 5 of the Payment of Wages Act. Subject to satisfaction of specific conditions, these conditions include wages. Under the ordinance, employees are not allowed to be paid less than the minimum wage. Health and safety, according to ordinance, the provision of Building and Other Construction Workers Act of 1996 and the Factories of Act of 1948 continue to apply. Work hours, employee will not be expected and work more than 11 hours a day, and total numbers of hours worked per day may not exceed 12. Bonded labor, the 1976 Bonded Labor System Act will remain in effect. It calls for the abolition of system of bonded labor. Bonded labor is a type of forced labor in which a debtor agrees to work for a creditor under certain conditions, such as repaying a debt owed to him or a family member due to caste or community obligation or due to social obligation. Women and children, the provision of labor laws relating to women and children jobs will remain in effect. Moving to the next slide, the unequal effects of COVID-19 crisis on the labor market. There has been so much concern about the wide-ranging loss of jobs and income after the pandemic and the lockdown. Particularly worrisome is that the impact of such shock on the workforce probably not uniform. The latest PLFX 2018-19 data, that is periodic labor force survey capturing labor market condition before the COVID-19 crisis, argue that it would have particularly harsh effect on the specific worker groups. According to the latest labor survey report, this would be under these would be undereducated workers who typically engage in low paid, unstable working arrangement circumstances in the stock sectors. Therefore, we can expect the crisis to accentuate the pre-existing inequalities in India's dualistic labor market, which has been characterized by stark disparities between, at one end, a small percentage of workforce that is engaged in jobs that offer stability of income and social security benefits, and at the other end, a disproportionately large proportion engaged in the informal employment. Moving to the next slide, labor laws to be key to compliance in the post-COVID era. A company, no matter how big and successful, it not far from trouble if not careful. It is not just the poor growth of a company in terms of production and service that may lead to its undergoing. It can extend to aspects that you previously might not have an idea about. Regulatory compliance is one such aspect, and quite an important one. This term, which not a lot of people are familiar with, can cause nightmares if one is not adhering to its terms, especially if you are a business owner or are involved in running an industry or company. Compliance shifts. The recent COVID pandemic and economic shutdown have brought the term compliance back to popularity. For those who are not aware of this term, it simply refers to the act of keeping oneself aware of the rule, policy, standard, law, or regulation recognized by a governing body and conforming to it to avoid legal troubles and penalties. This small term, however, comprises a wide array of laws including labor and industrial, the areas covering from wages to working hours to the workplace environment and safety to dispute resolution. Change in labor laws. A major boost to labor reforms, three laws, namely Occupational Safety, Health and Working Conditions Code 2020, Industrial Relation Code 2020, and Code on Security 2020, have been created by merging 25 central labor laws. This restructuring will ensure the well-being of industrious workers and give a boost to economic growth. The new labor codes have been designed to universalize minimum wages and timely payments of wages, while also give priority to the occupational safety of the workers. Helping employees and employers, the labor reforms will give proper control to stop exploitation of the laborers. The government step to introduce reform and restructure the entire scattered legal labor law framework during this lockdown could be step towards a fair work industry. The primary objective will be to safeguard the right of the employees. On the other hand, employers will also have a better control to run things even in matters such as hire and fire. The current reform will ensure such processes to go smoothly without the involvement of third parties. Business and worker friendliness. What good are labor laws if they can only protect one section of the workforce, particularly only from the organized sector? The labor reforms will impact over 500 million workers, which a lot more employees will be taken into account than currently. Apart from taking employers and employees into account, these reforms will also ensure that the parties involved are rewarded fairly and they are satisfied with it. The code on wages will ensure that there is no discrimination in an establishment on the grounds of gender, job roles, and that there are reasonable wages and eligible bonuses for the work done in comparison with similar work done by another person elsewhere. These reforms will help India's ease of doing business, credentials on account of codes, ensuring personal and professional satisfaction of employees and owner, concern on pay, safety, and social security. The online advantage. The pandemic and the lockdown have introduced norms and measures which are now being considered as the new normal with regards to both work and personal life. These norms attribute these norms attribute to social distancing, hygiene, and safety from contracting disease. So it should not be come as surprise that the future will have minimal physical inspection and complete use of technology could become an order to have business-oriented meetings. We have already witnessed the rise of online conference meetings lockdown, and it is a fact that a continuation of this practice will be time and cost efficient in comparison to traveling to a further place for meeting. All kind of documentation will also be digitalized so it can be sent across different places without much hassle. This will be the same with ensuring the proper implementation of labor codes. Concluding that the post COVID scenario, COVID 19 has been a learning lesson for everybody, including the compliance industry. This pandemic has prepared the compliance industry to be more prepared and flexible in case of further changing scenarios. It has shown even critical escalations and changes that can be new normal. As companies seems to revive themselves from the economic slump, this episode of the pandemic has taught firms that it is essential to maintain the culture of being compliant and adapt to quick changes and plan for a new and emerging risk and challenges such that compliance teams can easily migrate the risk and navigate through crisis period with ease. Thank you.
Okay, it's really wonderful, Anjali. And you have raised very pertinent issues that, the post-pandemic era, how different it will be. And, what kind of labor requirement we will have. That is another question now, because people are adopting to certain technologies which cut short the labor requirements. And as I told you, now it is going to be robotic age, artificial intelligence age, and one has to understand that what kind of society we want to build up, because different societies have different economic and political culture. There is a negative growth in Russia Europe, America, Canada, Australia, but there is a population growth in South Asia. And what is the reason of our backwardness? It is not because we have implemented these labor laws. The reason is that we have not been able to adopt to the technology which world has developed. And the Western countries are earning because of their technological advancement and less population. So these things, and the country like India, it becomes very difficult for it to implement the social security because given the type of population it has, more than 30% people are still illiterate, more than 98% people are constituting the unskilled laborers. And even our BTech engineers are, which are produced in millions every year, they are being hired as foremans, as workmans. They are not given their due jobs. They are to be hired as blue collar people. And these things have to be taken into mind, and India has to make a policy which has to take into account these all factors. So it's a good work, and it needs to be taken forward. That okay, whatever we are experiencing during the COVID period, but what is after that? Because now we have changed our lifestyle. We are having conferences through teleconferencing, and we are having digitalization of documents, and we have concentrated our stores. We have purchases online. So production is robotized. So these things have to be understood by the legislatures, and they have to work according to that. Mindless laws, we have more than 5,000 laws. As I told you that we have more than 50 laws at the center right now affecting the labor, and the states have separate 200 laws, and most of the lawyers, judges are not aware of all the laws. And this labor code bill, which has been enacted by the parliament, yet state has to make the rules and regulations how it can be enforced. It is not enforced as yet. So these things have to be understood, but still let us see some silver lining coming up, that social scientists, the legal luminaries will sit together and find some solution to that. Yes, Zainab.
Thank you, Ms. Anjali Kumari. So the
Thank
next
you.
speaker is Ms. Ritika Chaudhary, and she's a student at George School of Law, and she'll be presenting on suspension of labor laws in India amidst COVID-19 pandemic, a critical review. Ma'am, are you here?
Yes, I'm here. Am I audible?
Yes, you are. You may present.
Okay. Is my presentation visible?
Yes, ma'am, it is.
Okay. Good afternoon, everyone. My name is Ritika Chaudhary, and I'm a final year student I'm pursuing my BLLB from George School of Law. It is affiliated in the University of Calcutta, West Bengal. So my research paper is on the topic suspension of labor laws in India amidst COVID-19 pandemic, a critical review. Coming to the next slide, COVID-19 pandemic. Coronavirus or COVID-19, a virus that restricts us within our homes, no social gatherings, and a complete halt in our daily activities. The virus, which was initially developed and infected many people in Wuhan, China, has now reached every corner of the world. Each and every country is struggling with this pandemic situation. But the worst part is that the working class population, especially the people from unorganized sectors like workers and laborers, are the unsung victims of this pandemic. The deadly and infectious virus not only took away millions of lives, but also jobs, means of livelihood of people of unorganized sectors and left them in starvation. India, a country with a total population of 1.3 billion, world's second most populous country, its sudden announcement of lockdown on barely 4 hours of notice left the 120 million migrant workers, many of them who are daily wage earners, in despair and with uncertain futures. An unplanned lockdown with no aid exposed the migrant workers and the other laborers to unbearable pain and suffering. Coming to the objectives of this paper. The objective of this paper is to focus on the status of labor rights in this pandemic situation and a critical review on the suspension of labor laws in India amidst COVID-19 pandemic. Suspension of labor laws in India amidst COVID-19 pandemic. It is done by several states in order to boost the economy is another dimension of this pandemic situation. On May 5th, 2020, the Madhya Pradesh government, through official gazette, amended the Industrial Dispute Act 1947. On May 8th, 2020, when Uttar Pradesh government promulgated an ordinance called the Uttar Pradesh Temporary Exemptions from Certain Labor Laws Ordinance 2020 that suspended 35 out of 38 labor laws in the state for 3 years. Various acts are included in this like Minimum Wages Act, the Trade Unions Act, the Industrial Dispute Act, and Factors Act, etc. Similarly, many states like Gujarat, Rajasthan, Himachal Pradesh, Assam, Goa followed the same path. Suspension of labor laws, its pros and cons. Like every coin has its two sides, in this way, suspension of labor laws has its pros and cons. Now coming to its pros. Most of the labor laws only enabling harassment from inspectors. Suspension of labor laws will bring efficiency in economic activities. Some business owners will be able to cut corners with impunity and make more profit than they ethically should have. Now coming to its cons. Suspension of labor laws ultimately violates the legal protection of the workers and laborers in India as it takes away their legal protection. It stands unconstitutional as it violates the fundamental rights of the workers. Workers and laborers are most exposed to this serious exploitation. The suspension of labor laws condemning workers to slavery. Only business owners are getting benefits through this act of the state government. A dangerous precedent is being set, establishing dangerous practices that lead to exploitation and labeling them as unreformed. And the last point is that the suspension of labor laws stands in violation of the International Labour Organization Convention number 144. As we know that the International Labour Organization is a United Nations agency whose mandate is to advance social and economic justice through setting international labour standards. As India is one of the founding members and has been a permanent member of ILO governing body since 1922, it is a duty to respect the framework of the ILO. Now coming to its critical review. As we know that the Constitution of India, the supreme law of the land, provides numerous protection for ensuring the protection of the labor rights of the workers and the laborers in India. Under Article 13 of the Constitution states that no shall be deprived of his life or personal liberty. The Constitution also recognizes right to livelihood as an integral part of the fundamental right to life. Suspension of labor laws in Uttar Pradesh directly violates the Article 21 of the Constitution. The reasons are the suspension of labor laws like Industrial Dispute Act 1947 will empower the employers to act at its own will. It results in insecurity of jobs among the workers. Coming to the next point, the Factory Act 1948 ensures the safety of workmen and ensures good conditions in the working place like availability of drinking water, safety, electricity, etc. Suspension of such law will be a direct impact on the working conditions in factories, and in this COVID situation, it is necessary to keep a check on this factory's condition. There will be an adverse impact on the safety of the workers. Now coming to the next point, the Minimum Wages Act 1948 ensures the minimum wage to be paid to the workers. Due to COVID-19 pandemic, the workers are already stressed up. Suspension of this act will create an instability regarding payment of wages. In the UP government ordinance, 4 laws are exempted from the suspension, one of which is Bonded Labor System Abolition Act 1976. The act will enforce the laborers to work as bonded labor so that they can be underpaid below the minimum wage amount. So this is the main concern regarding this. The Trade Unions Act 1926 is also one of the 35 suspended labor laws. Suspension of this act empowers the employer that he can terminate any worker who decides to form a union and hire others. Equal Remuneration Act 1976 ensures equal remuneration for all. It ensures that the women should not be deprived in terms of wages. Suspension of this act violates Article 14 of the Constitution that ensures the fundamental right to equality. Wages should be determined on the basis of the amount of work done by the worker and not on the basis of sex. The suspension of labor laws also violates the International Labour Organization Convention number 144, to which India is bound because India is one of the signatories. And I would like to conclude that the state governments are trying to favor the business for industrial growth and are not concerned regarding the labor rights and its protection. Such overlook will take India a step back to its labor reforms. As labor comes under the concurrent list, the central government should come forward and look into the matter, and judicial intervention is much needed in order to stop this unlawful ordinance. India needs to uplift its working class population, especially from unorganized sectors. Financial aid, employment opportunities, decent wages, etc. should be given by the government to its citizens in order to make the country more stable and strong. By this, I'm ending my presentation. Thank you.
Well, India is again forgetting that less than 30% population is still below poverty line. And that poverty line definition, we all know that how, it is predatory. And according to the Tendulkar report, 77 crore people are earning less than 20 rupees per day. And by suspending these labor laws, what do we want to achieve? That is again a concern without providing any social security. Okay, you suspend the labor laws, but you should have a strong social security paraphernalia, which we still lack despite the food guarantee program and Manrega and all. The people are dying of hunger. Farmers are committing suicide. And the process of globalization also requires that we should have a strong adherence to human rights. And in 1948, 10th December, the Treaty of Westphalia, which was agreed upon by the various nations about the sacrosanct nature of sovereignty was falsified by the formation of United Nations, which says that any country can be interfered with if it violates the human rights of its citizens. Then no law is applicable, no international law is applicable wherein it calls for that you cannot interfere in the domestic matters of any country. So, you know, the sovereignty which is protecting the policies and programs of a country is rendered useless if it violates the human rights. And if workers are not given their rights, then it means they are violating the basic human rights of all human beings, and United Nations can enter into the conflicts which arises between workers and capitalist workers or state. So, Ritika, well done. You have, in very few words, you have conveyed so many things, and wish you all the best. So, next speaker.
Thank you, Ms. Ritika Chaudhary. So next speaker is Miss Kinjal Bog, and she's a student at SVKM's Pravin Gandhi College of Law. And she'll be presenting on employment and labor issues, qua termination and payment of wages during COVID-19. Ma'am, you may present.
Her name is Kinjan.
Kinjal Bog.
Kinjal Bog.
Hello, I'm Ms. Kinjal Bag. Today I'm going to present on employment and labor issues for termination and payment of wages during COVID-19. Next slide. Um, Here I start with short introduction. As we are aware, the novel coronavirus outbreak that gave rise to a disease called COVID-19 has led to an absolute disruption of global activities. The World Health Organization has declared it a pandemic and countries are observing a lockdown to fight it. This has necessitated balancing the rights of employers and employees in this COVID-19 crisis. With activities having come to a halt, businesses have been forced to take steps to reduce the pandemic negative impact. Amidst rising concerns, one question which has crept into the minds of the employees across both blue collar and white collar jobs is the issue of job security and payment of wages. Almost every industry is grappled with the problem of liquidity, and thus these steps, which I'm going to discuss, have become imminent. Next, advisories issued by the government of India and state governments. The fear and uncertainties in employment have become more prevalent during the ongoing COVID-19 crisis. Imposition of the first order of lockdown and subsequent extensions of the same has crippled the economy and impacted adversely the majority of businesses. During the ordinary times, if an employee is discharged, he may seek an alternative employment. But in the prevailing situation, the labor market has become paralyzed, and the employers are not willing to recruit new employees. In these circumstances, an employee who is discharged would be unable to get any gainful employment during the lockdown. The central government invoked the Disaster Management Act 2005 on 24th March 2020 and enforced an initial 21-day nationwide lockdown. Before the first order of lockdown, the Ministry of Labor and Employment, Government of India, on March 20, 2020, had issued an advisory requesting the employers not to terminate any employment, particularly of contractual or casual labor. It also went on to mention that if any employees take leave or due to COVID, the place of the employment is made non-operational, the employees should be considered to be on duty for this point with non-consequential reduction in salaries. The apprehension of migrant workers that they wouldn't be able to survive such a wage-free lockdown initially led to a violation of the lockdown laws, um, uh, to a panic exodus of migrant workers to their homeland in some parts of the country. The MHA took notice of the situation and issued instructions to take some additional steps while the order dated 29th March 2020, so as to alleviate the economic hardship faced by the migrant workers. Notably, Clause 3 of the said order specified that all employers, whether in industry or in shops and commercial establishments, shall, on the due date, make payment of the wages to their employees at their workplaces without deduction for the first time during which their establishments are closed during the lockdown period. An order dated 31st March 2020 under Section 24 of the Disaster Management Act 2005 was subsequently issued by the Maharashtra government. According to this order, the employers are expected to pay full wages and allowances to all or any contractual, outsourced, temporary, and daily wage workers during the lockdown period. Similarly, several other state governments such as Rajasthan, Punjab, Telangana, etc., released orders similar to the MHA order informing workers of the payment of full wages during the lockdown time. Next, the ID Act. A workman is described by Section 2F of the IDA as any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be expressed or implied, and for the purposes of any proceeding under this Act in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute or whose dismissal, discharge, or retrenchment has led to that dispute. The concept of workman has been given with some exceptions, including inter alia, an individual who is primarily employed in a managerial or administrative capacity, and if such person's wages exceed rupees 10,000, the services of such individuals, which are protected by the exceptions to the concept of workers, shall be regulated by the respective service rules if they are government employees or by their employment contract if they are private employees. Section 25M of the Section 25 of the IDA has relevancy to the current situation of the COVID-19 and to the measures envisaged by employers. As discussed, it reads like it is under. I request to go on the next slide, please. No workman other than a buddy workman or a casual workman whose name is borne on the muster rolls of an industrial establishment to which this chapter applies shall be laid off by his employer except with the prior permission of the appropriate government or such authority as may be specified by that government by notification in the official gazette obtained on an application made in this behalf unless such layoff is due to shortage of power or to natural calamity. And in the case of a mine, such layoff is due also to fire, flood, excess of inflammable gas or explosion. Next, the Disaster Management Act 2005 and the Epidemic Diseases Act 1897. In the case of Swaraj Abhiyan 1 versus Union of India, Apex Court observed that the object of Disaster Management Act 2005 isn't just to draw up, monitor, and execute disaster response, but also forestall and mitigate the effects of a disaster. Section 2D defines disaster management as a persistent and integrated process of planning, organizing, coordinating, and implementing measures essential or expedient for counteraction of peril or danger of any disaster and mitigation or reduction risk of any disaster or its severity or outcome. Mitigation is defined under Section 2I as measures aimed at reducing the risk, impact, or effect of a disaster or threatening disaster situation. It is provided under Section 35 of the DM Act that subject to the provisions of this Act, the central government shall take all such measures as it deems necessary or expedient for the purpose of disaster management. Further, Section 35 of the DM Act stipulates such matters as the central government deems necessary or expedient in order to secure effective implementation of the provisions of the said Act. Likewise, under Section 38, a state government has also been empowered with similar powers. The Act does not explicitly accommodate a mandate under which the employers can be directed by the central government or a state government to take steps in the nature of laying off or reduction or deferment of wages. The Epidemic Diseases Act 1897 has also been invoked by the Government of India, wherein appropriate steps may be taken and regulations can be prescribed concerning a dangerous epidemic disease by the central government or a state government. But even this doesn't contain any provision which mandates to take such steps. The Delhi High Court, in the case of Kritika Padate or an ANR versus Union of India and ANR, while deciding the status of an advisory for not broadcasting a documentary issued to private TV channels, held that the advisory dated 3rd March 2015 was just a mere advice given to the private satellite TV channels. Considering the extent of the DM Act discussed, apparently a mere advisory given by the central government or the state government wouldn't have a binding effect on employers and mandate them to not terminate their employees. Now comes the analysis. In view of the Section 25M of the ID Act, employers may argue that the layoff of a workman is permissible in the case of a natural calamity. And since COVID 19 has been declared as a pandemic, resulting in a complete lockdown of economic activity, barring a few essential activities, the layoff is permissible in the present scenario. The Supreme Court reversed the order of the High Court in Ashok Kumar Jain and others versus State of Bihar and others, and declared Section 25M as ultra vires the Constitution. It was held that the layoff in question was resorted under compulsive circumstances and was not motivated or unjustified. Thus, there was no lack of bona fides on part of the industry in effecting laying off. Moreover, a cohesive reading of the DM Act, the ED Act, and the advisories issued by the Government of India and various state governments suggests that these advisories are not binding due to the absence of explicit provisions in the DM Act or the ED Act, and in view of a specific exception provided in the ID Act. Further, it is provided under Section 72 of the DM Act that this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being it for. Hence, even after taking into account the overriding effect of the DM Act, the said Act does not mandate the employers to take the step discussed in the light of a pandemic. Next, employment or labor related litigation arising out of COVID 19. An unusual circumstance such as this is also likely to give rise to complicated legal problems, and as a result, there has been a flood of litigation initiated by the employers as well as employee association in the light of the advice provided by the government of India and various state governments. Nagrika Exports Limited has lodged a complaint before the Supreme Court questioning the constitutional validity of the order of 29 March 2020 issued by the MHA, and accordingly the order of 31st March 2020 issued by the government of Maharashtra to the limited extent that it provided for full payment of wages during the lockdown time. The company reported that due to the shutdown of operations, it had to face substantial losses, and in compliance with the said order, the company had disbursed full salaries to all his employees for the entire month of March. The losses of the petitioner would only multiply with the lockdown extended, and if the company had to comply with the disputed orders in their entirety, the business itself would become unsustainable. It was also pointed out that the state of Maharashtra had itself agreed to pay the wages of its employees in installments in an attempt to cut costs and delay those expenditures during the COVID 19 crisis. In the aforementioned petition, an intervention request was filed by some of the largest trade unions in Maharashtra, alleging that the orders given by the MHA and government of Maharashtra were sufficient steps to safeguard the basic rights and support of poor workers in the face of serious problems and these social and economic problems caused by the lockdown are evident. Another petition was lodged before the Supreme Court by Ludhiana Hand Tools Association, consisting of 41 members, assailing the MHA's order of 29 March 2020 to the degree that it ordered payment of full salaries during the lockdown period. In a petition filed by Technonym Construction Limited of Rajasthan, a similar petition was filed and a notice was given. These petitions contend that the central government lacks the legislative power to direct private institutions to make full payment of salaries to their employees, and that the order challenged it is unconstitutional, arbitrary, and in violation of Articles 1491, sorry, 191G, 265 and 300A of the Constitution. The arrangement between an employer and an employee was argued to be reciprocal, whereby an employee's right to demand compensation is reciprocal to an employee's success, and the employer has the right not to pay if no work is completed. In addition, regardless of the profit and loss made by them or their turnovers, it is unfair to treat all private establishments equally. Since then, a number of other petitions have now been moved on the same basis before the Supreme Court, and no interim relief has been provided to date. A petition has also been recently lodged before the Bombay High Court by Align Components Private Limited and the company ANR against the order of the MHA of 29th March 2020. It was argued that the petitioners were willing to give the workers job, and while the workers were willing to perform, it was mandated to reduce or shut down manufacturing activities in the order to limit the spread of COVID-19. However, no interim relief was given, and the High Court held that it expected the petitioners in the cases of those workers who were not required to report for duties to pay the employees gross monthly salaries except for conveyance allowances and food allowance. It was also explained that employers were free to deduct the salaries of workers who voluntarily stayed absent from duty in industrial areas where the lockdown was partially lifted by the state of Maharashtra. I would like to conclude next slide. The current situation is unparalleled and intricate. The world is seeing a mass migration of migrant workers working in different parts of the country to their respective native places with regard to COVID 19. Owing to the lack of child food and health services, this has led to many fatalities. The central government itself has agreed to delay the payment to its employees of dearness allowance and dearness leave until July 2021. Several state governments has also agreed to either delay their employees' payments of salaries or pay the same in installments. This raises a relevant question. When the central and state governments have taken a deliberate decision to make partial payment of wages to their workers, expecting private in this establishment employers to do so by stretching themselves in the midst of severe cash shortage expects a little too much from them, and such establishments need support from the government. The legal position under the IDIPM Act and ED Act is probably going to make it tough for the workmen or employees, since the advisory discussed might not ultimately not have a legally binding effect. Thus, a balanced approach is needed to address the issues of the business as well as the laborers or employees. For example, since the declaration of lockdown, the sales in the auto industry have become zero. From an already reeling industry, if it is expected that it adheres to the advisories issued by the government, it would be practically asking to shut down the business. While workers continue to struggle, in view of the pandemic, several states have recently taken measures to reform labor laws. For, for the moment, all labor laws have been suspended in the state of Uttar Pradesh. Although it may ease enforcement problems as far as employers are concerned, enforcement with anything like the 1948 Minimum Wages Act and other protections, social security laws available to staff and employees is also eliminated. Thus, this will lead to a general drop in the wage rate, which will leave most businesses practically unorganized. Notably, by the means of the wages, allowances, and pensions of members of Parliament Amendment Ordinance 2020, the central government has taken steps to reduce the wages, allowances, and pensions of members of parliament by 30% per period of 1 year in an effort to tackle the current crisis. On 12th May 2020, the Government of India announced an economic package of 20 lakh crores, which is approximately 10% of the country's total GDP, which, among other reliefs, is expected to provide relief to local production, details of which are expected, with a view to providing relief to unskilled employees, the cottage industry, and MSMEs. This package has been released. This step's usefulness remains to be seen. Taking into account the measures taken so far, what is currently expected from the for the government to provide employers with a wage subsidy or financial assistance in the form of allocating a certain percentage of GDP towards the wage burden? The government also needs to do more by taking adequate steps to resolve the problem of migrant laborers and their exodus. Thank you so much.
Okay, Kim, it's really enlightening to see that how you have projected the whole COVID scenario with which we are dealing for the last around 1.5 years. And this has a very startling statistics that certain part of the world are very severely affected. There are countries which are not affected. China, which from where this coronavirus originated, is enjoying itself and is not affected as much. Countries like America, Brazil, UK, Spain, Italy, and now India are badly affected. And despite the welfare policies of the government, so much of announcement of 20 lakh crore rupees during the COVID period to the industry, to the workers, we have not got relief. And in fact, people have committed suicides. Our so many lawyer friends have committed suicides. Even doctors have committed suicides. Several laborers have committed suicides, or they have been killed due to lack of medical facilities, due to migration back. And several things are there, and it is really proving to be a big complexity, that whether this is a natural calamity or it is a bioterrorism, because you never know. Terrorism used to be there, and if terrorist attacks used to be there, we used to know that who is the terrorist, where the terrorist sitting. But in the case of biological warfare, which is going to be now day-to-day occurrence, and it is not easy to get rid of. You never know who is the culprit, from where the virus has come, who has spread the virus, who is the terrorist. This is a great calamity. It is a human-made calamity. Now glaciers are melting, and out of those glaciers, very deadly viruses are likely to attack the life here on this earth. And now I don't know how scientists are going to grapple this. Just like when people who have taken vaccine, they have been vaccinated, they are being now dying. So, this is a very complex situation. It is not now only in the ambit of legislature or legal fraternity to talk about it. Put together psychologists, so many students have committed suicide, psychologists, sociologists, economists, and politicians have to sit together, and we have to organize an interdisciplinary research to tackle this problem, and it is likely that it will continue for the next 4 to 5 years, because single mutation, double mutation, triple mutation, every time the virus is changing its color, changing its symptoms, so it is creating lots of problem. And given any calamity, it is the poor people who suffer, whether it is a war-affected state, whether it is a terrorist-affected state, whether it is a biological warfare, biological natural calamity, every time a poor has to suffer. So we have to look this whole scenario from this point of view. So it's a good work. And from which university you are?
So Mumbai University.
Okay, very good, very good. Wonderful to see you. Which year you are studying in?
Third year, sir.
Very good. 5-year course?
Yes, sir.
Okay. So anyway, get in touch, and we have series of conferences. So be with us, and it's a really wonderful work. So anybody else left?
No, sir. She was the last speaker.
She was the last speaker. So, okay, we have to wind up now. We was thinking of having a valedictory session. Actually, our friend advocate Sanjay Chadha has a serious family problem. There are some deaths. in his family, so he has not been able to join. So wish all of you a good health, and I wish you all survive this pandemic without any damage. So I thank all of you to come and present your extensive research work, and we will be thinking to publish it somewhere. And let me talk to my team if this could be brought into a book. So hope to see you all again. Thanks, Zainab. Zainab has wonderfully conducted this session. She has anchored so wonderfully. And once again, I am thankful to Professor Cole, who, despite his ill health, agreed to be the chief guest and chairing one of the sessions. So thank you, friends. Hope to see you sometimes and get in touch with us. My number is with everybody. You can anytime contact me. Thanks a lot.
Thank you so much. Thank you, Dr. Vipin Malhotra, sir, and Sanjay K Chadha, sir. And thank you to the other speakers who presented very well. I hope you all stay safe and stay at home, please.